leadership, the Chief Justice, will be joining us. And therefore, to save on time and ensure that we are able to do what we are required to do, we will today start with the second session. And then as soon as the Honorable, the Chief Justice arrives, we will revert to the other program. So essentially, we will swap so that the second session for the day will start us off, and then we will revert to the other one. I just want to provide an overview of what took place yesterday, and then I'll invite Mwalimu Elisha Ongoya and the panel that is supposed to be in the second session to join us so that we can have that session start. Essentially, yesterday we had the first session where we really set the tone for the conference, and quite a number of highlights were provided by the guests that we invited. Ms. Faith Odhiambo, the LSK president, set a stage by looking at the standards, and she asked that, does the standard of legal education stand up to modern day or contemporary complexity? And that is the question that we sought to address even as we set the stage. And key emerging issues that were raised included concerns on curriculum, integration of emerging technologies, including AI and virtual assets in legal education, anti-money laundering, and competencies, regional harmonization, and enhancing stakeholder collaborations as part of the important areas or elements that we needed to address. The objective was to transform legal education to produce globally competitive, ethically grounded, and technologically literate advocates. So the transformation pillar that was set out were threefold. First one was curriculum reforms, second, skill development, and third was cross-border practice. And we had a very fruitful engagement. Honorable Gitobwi Manyara did present that in the contemporary world, Kenya needs more lawyers for global markets. So he was of the view that we need a global lawyer for the global market. There was also a presentation both from the LSK where concerns about competency and capacity of the current advocate was raised. There was a unanimous consensus that the concern is not the number of lawyers that we are producing, but the quality of advocates that are being produced. And Professor Kameri Mbote put it quite elaborately that it is not how many institutions that exist which offer law, but who teaches, where, when, and how these students are taught. So that theme helped us to deconstruct how the as from the council. It has been a challenge, and the process needs to be reformed or refined to ensure that we have a clear framework for addressing this issue. So those are the highlights of what happened yesterday. I now want to invite Mwalimu Elisha Ongoya so that he can invite the panelists. We can have that session started, and then when the guest of honor arrives, we'll welcome her. Hopefully by that time, that first panel would have ended. Thank you very much.
A very good morning to everyone who has already joined us. I would ask us to sit down and now focus so that we can listen to our eminent panelists and paper presenters. My name is Elisha Ongoya. I'm an advocate of the High Court of Kenya. I'm also a senior lecturer at the Kabarak University School of Law, which is one of the legal education service providers in the Republic of Kenya. I am privileged to be a moderator for this event. And just very briefly, because we are starting a little late, approximately 25 minutes late, I always regard it as the obligation of the first moderator to recover lost time. And therefore, we are going to recover lost time by ensuring that we spend the time allocated for this panel less the time already spent welcoming guests and settling down. So may I ask our panelists to come to the front and take their seats. I may need one more seat on the stage because I'll have both the panelists and the paper presenters on the stage. So protocol team, I'll need one more seat at the front and another microphone. Professor Mike Kuria, kindly take the stage. It's free sitting, so you can choose the seat that pleases you the most. Is Dr. Henry Murigi already in the house? He was running a little late. Yes, Dr. Henry Murigi is here. Thank you so much. Then for the paper presenters, I would have Dr. Melissa Muindi, who is already in the house. There. And then I'll have Mr. Paul Martin Konyango join her on the stage. Thank you. Thank you. I trust everybody has their microphone. The two paper presenters can wait. At least the two panelists have the microphone. Thank you, because you'll speak from there. I would, for the time being, use this platform to do my engagement. So just very briefly, Professor Mike Kuria, very briefly, is the CEO of the Commission for University Education, which, as we know, is the overall regulator of university education in this country. Dr. Henry Murigi is the registrar and CEO of the Nairobi Center for International Arbitration. And we are going to have a conversation with the two of them. So I'll pose questions to the individual panelists. And that session of the panelists is supposed to terminate, at least as per my schedule, by about 10:25, so that we save on time meant for the next session, so that at the end of the next two sessions, we should have recovered time fully and we should be at around midday. So that's it. I trust that your microphones are ready. If they are not, our technical team will have to pick it up from there. I was waiting to see whether my seat has a microphone, but since I can't see it, I'll do it from here. So, Professor Mike Kuria, I'll start off with you. Our theme of conversation this morning is on competence-based legal education, aligning curriculum to emerging global trends. And perhaps we would be better placed if we began by understanding what are the standard best practices in curriculum development. Just the standard best practices first, before we go into any specifics. Over to you, Professor Mike Kuria. The technical team, I began by expressing my hope that the microphones were working, but I've said elsewhere, hope is not a method of doing anything. Thank you. We can work with that.
Thank you very much. First of all, let me say I'm thankful to have been invited to this meeting where we are talking about education, for legal education for that matter. Especially glad because in Kenya we are trying to make sure that the Commission for University Education works as closely as possible with the professional bodies. And one of the reasons why that we are doing that is what you have just raised. If you look at the strategic plan of the Commission for University Education, one of the issues that we are focusing on is the question of internationalization. And internationalization won't happen unless the curriculum we are developing are also aligned with international practice. And so meetings like this where we are engaging with other people from other parts of the world, and especially in the context of the 2017 declaration of East Africa as a common higher education area, is very critical for us. And so I'm very glad to be here. Now you asked about what are the principles we look at in terms of curriculum development. Now, if we begin from the context of the introduction of the CBE in Kenya, I would say it begins from the whole idea of competencies as opposed to just regurgitated of knowledge. And so we want to look at the competencies that the graduates will be able to demonstrate. And the idea is that we are not focusing on what they know. That's not to say that you don't focus on what people know, but you will need to see what they can do with that knowledge. That leads us to several things. That the curriculum has to be developed with that in mind, and that means that teaching methodologies have to be aligned to
the curriculum that we develop and we use here. So the paper looks at that and makes the argument that for lawyers we have to relook at our curriculum and address the question, because when you look at arbitration history, you will figure out that it began with merchants and seafarers meeting together and resolving disputes. At some point, lawyers realized that, wait a minute, the services you merchants and seafarers are trying to do there are actually what we are trained to do, which is to give justice. So lawyers quickly took over that space and they hijacked the space. But from my experience, I have seen that the merchants and seafarers, who are now called architects, engineers, businessmen, bankers, are beginning to come back for their space. They are beginning to get arbitration training, and they're beginning to get skilled, relevant training, for example, in construction industry. So if you go to the construction industry now, you will find mediators, arbitrators. So the lawyers are quickly being jostled out of that space. So there is a need to relook at how we train our lawyers and the skills we develop. I asked the question in the paper, why don't we consider preparing students who graduate from our law programs with mediation skills, for example, so that they are ready to conduct a mediation by the time they conclude? Why don't we train them to be competent arbitrators? One of the things you will see, Mwalimu, is that when you look at the curriculums for all the universities, ADR is used as just one of the units. And what we do is a high-level summary. So there is no skill really that is drawn out. So Mwalimu, the future is calling us to rethink our curriculum so that we produce skill-ready arbitrators and mediators so that we can be able to address the growing concern. So Mwalimu, back to your question. You asked about the future. First of all, I'm not a prophet, but at least we can learn from history and be able to tell perhaps where the journey is going. And I'll be brief in this. Mwalimu, what I see is that the future is demanding for virtuous practitioners, people who are committed to duty, people who are committed to ethics. Because at the international space, those are the non-negotiables. If we begin to have a conversation at the international space, and if we want to develop a curriculum on ADR that addresses the global competitiveness, there should be no doubt as to the virtue and ethics of the practitioner that is being produced from our law school. Let me stop there in the interest of time. The rest, I think, can be read in the material that I've prepared.
Thank you. Maybe I would also pose the same question to Prof. Mike Kuria. That future, I'm sure at the Commission, this is your daily concern. We're running a higher education that is future ready or that is stuck in the past. What is that future looking like? How do we pictorially present it so that those who are developing curricula then can have it as their constant north as they put pen to paper to write the curriculum? Prof?
One very specific one, which I think has become my pet topic a little bit these days, is the future, in my view, the way it looks, will do away with rigid curricula. There may be a possibility in the future that students will come to the university and say, this is what I want to do. I want to achieve that, that, and that, and that. And if you add it up all together, it seems to point to that particular kind of qualification. I know this is sounds like a weird idea, but in my view, the future is very flexible. So one of them is that it's possible that students will design their own curricula in the future, and they design their own degree. That means we may have to rethink the nomenclature of the degree programs that we have. And if we don't, because we are now moving to the idea of competency rather than just the certificate. So as an employer, when a graduate comes to me, I'm not really interested in whether they have a piece of paper that says they are first class. I am saying I have a problem that needs to be resolved where I am working. Can you resolve it? And if students can design something that will make sure that they are providing solutions for the society, those graduates are likely to become more marketable and more acceptable in the labor market. And I think I didn't say that at the beginning, but the whole question of designing degree programs that are aligned to the labor market, a close connection between the universities and industry, I think would be critical. But we have to be careful in the sense that the industry is not constant. It's going to be changing. When the industry tells you, give us market-ready graduates today, but tomorrow that industry will be different. And that industry of tomorrow will ask you to give us market-ready graduates now. So what happens if we train those graduates in a very inflexible way? So flexibility, in my view, is going to be the future of the curriculum. We need to think about that, and we need to be open to that idea. I know that in some parts, in some areas of professionalization, they are now also even bringing this whole idea of micro-credentials. So that a student can stack up these micro-credentials and move to other particular qualifications. I know that we in regulatory agencies, we are usually very rigid about this. We don't want to change, for good reason sometimes, because we also don't want anybody to claim to have achieved competencies in any area and come with a piece of paper and say, I've been certified by someone who we don't know. So we need to make sure that we protect the environment, but at the same time, we must be open to the idea that the future is going to be very tech-driven and also very flexible, and for that reason, we need a flexible education environment, maybe even a flexible idea of what a curriculum looks like.
I'll follow up with you on this. I'm sure the Council of Legal Education that is here, I am regulated by that council, so I know something about that council as a recipient of their regulatory warnings and encouragements sometimes. And regulation demands standards. Yes. And standards come with an element of rigidity, because standards, you want to know whether you are complying yourself. So you say, okay, give me the checklist. And with a checklist is an element of rigidity. What would be the role of regulators in this flexible curriculum future, where I am here trying to build a market-ready graduate by adopting flexibility, on the other hand, trying to satisfy the regulator who has a checklist. And on the day they visit, they will ask, let us see, how have you complied with 1, with 2, with 3, which imports an element of rigidity into it. I don't know whether the commissioner has thought about how that balance, if at all, will eventually possibly be struck, or the pathway to striking that balance.
Yeah, I think, first of all, in one word, it's a difficult thing to say because, as you said, regulation demands rigidity. And I'm in the area of regulation. So I also want I want to be convinced that if someone says they have certain competencies, I can be able to establish that indeed they have those particular competencies. So I understand that. But I also want to see how that regulation is not so rigid as to stifle creativity and innovation. So my thinking is that we as regulators, what we need to be able to do is to provide guardrails. So that you can operate within a certain environment that we are agreed upon. And if we provide those particular guardrails, we provide an opportunity for you to be creative and innovative, but the ultimate idea is the same product. You see, if you want I usually use a very simple example, not in legal or any other field, but just to say that if I wanted to hire a driver, and I just want to test them whether they have the competencies to drive a car. And I say, this is take that car from here and park it here in angle parking. And someone demonstrates that they can be able to do that. I should be able to recognize that particular qualification. And some people are coming with this whole idea of recognition of prior learning. Again, this is where we regulators are a bit rigid. Because you come and you ask us to recognize prior learning, and then we ask, where did you learn it? Who certified it? What was the content of it? These questions are legitimate. But I think we are open to the idea that it is possible that that driver has learned how to move his car and park it over here. And for that reason, we can recognize that particular aspect. It doesn't mean that we can also trust them with a Ferrari to drive it at whatever speed, because we only tested that particular area. So is there a way in which we are flexible enough to allow learners to be able to stack up their qualifications, as long as we can be able to recognize those within those particular guardrails that I'm mentioning?
Thank you. Thank you so much, Prof. I'll go back to Dr. Henry. And Dr. Henry, you mentioned something about ethics. And I've been reflecting on this question of ethics, as ethical concerns in legal education, training, and practice. I'll be moving to the element of the next industrial revolution, the digital economy, in due course. But I'm reflecting that if we look at the role of digitization in industry, in the labor market, it means that the non-physical person, the digital person, is going to do a lot of work that we know today. And yet we continue training the physical person at the university. So what competences first are we supposed to give to this physical person to make him usable, user-friendly in that digital economy first, before I go to the ethical concerns?
Okay, thank you. Mwalimu, that is a very good question. And I was afraid when you took the format of question and answer, that you would throw that type of question, that type of curveball. So I think my attempt at it would be as follows. The growth of technology is not something really new. Human beings have interacted with growth of technology in previous eras. And what emerges always is that the human being must always reinvent and reimagine and recalibrate himself to be able to survive in the new technology. In the same way, in artificial intelligence and the growth of big data is introducing a new dimension, which the trainers and legal education providers must be able to address that. However, I believe that the human being will still remain the most important person to focus on. In fact, in terms of even training, how do we focus on them so that when they engage with learning, they are engaging with learning how to be ethical as they use artificial intelligence or technology. So that's the first thing that I would say. The second thing I would say is, and now situating it in alternative dispute resolution mechanism, we are seeing time and again the growth of things called smart contracts. Smart contracts that have clauses in the contract that require that should a dispute arise, it will be resolved through online dispute resolution mechanism. So the contract is smart enough to be able to determine who's going to be the arbitrator, who's going to be able to determine this dispute. What are the criteria that we need to be able to engage as a party or as an advocate advising a party? How do you engage with that type of person? So my view is that when you're training, especially on arbitration and mediation, we are always encouraging practitioners of ADR and even parties who appear before arbitrators to be aware of this and to be able to gain as much knowledge of the tool, because AI is a tool. Gain as much knowledge of the tool and be able to use it ethically to be able to then produce justice for the party. Because I believe at the end, human beings are pursuing justice. And what they want to see is just outcomes. Just outcomes are very important to the human being. So if we're able to train advocates who will be very much conversant with what the just outcome looks like, then technology becomes one of the tools, just the same way you taught us, Mwalimu, to read case law. Just the same way you taught us how to read books. So in the same way, we need to read AI to understand how to use it ethically.
Back to you. Dr. talks about just outcomes, and just outcomes are something more than just something, talking about the legal experience. When a dispute comes before a properly trained, properly schooled ethical lawyer, there is the law. Then there's the element of empathy, the question of being able to read the emotion. The parties before you are real human beings with blood flowing through their veins. They have emotion. Technologies may not be suited to deal with those elements of just outcome. A just outcome will address itself to the dry letter law, but also to empathetic elements, emotional elements. How do we design a curriculum to ensure that the product that it produces is sufficiently filled with those human elements? Is that a concern of curriculum? Or should we leave that to people's priests and bishops outside the curriculum to deal with, to fill up the gaps? Prof.
I think that's a very difficult question you ask, but I think the short answer is that yes, curriculum must be focused. In fact, in the context of what he just discussed about AI and technology, the risk we have is to lose inculcating into our graduates those human skills. Because they can eliminate you as a teacher and use AI. They can engage. You don't have to interact. They can actually learn from wherever they want to learn from. But there are certain things that you learn, not necessarily from what the teacher says in class, not what the students say in class, but in the interaction of yourself and the students. So as we go into this whole idea of virtual learning, and online and distance learning, whatever it is using technologies, we really must think about how we make sure we don't lose that element of being human. And I think when you talk about the empathy, emotional intelligence and things like that, these are elements of being human. And if we are not careful with our education system, it's possible that we can lose that. I think that's one of the greatest challenges that technology is bringing into us. When you realize that you can have a companion who you can talk to at any time of the night, they don't get tired, they don't get angry, they are always nice to you. You can easily say, why do I need a human being? So in our curriculum, we have to really think about how do we, for example, how do you know that the lawyer that you have trained is empathetic? How do you know that they can exercise emotional intelligence? So these are very difficult things to measure, but I think we must focus on them and see how we can inculcate that by making sure that then the exams are not what I just said before. Just because someone is writing a very nice story does not mean they are nice. They can tell you nice things. You probably need other methods to test whether that student actually acts in a just and consistently just way.
Sorry, while at the same thing, the fear by the university teacher, 90% of the university teacher of today is trained in the environment of yesterday. And yet he has to prepare today's student for the future environment. And there lies the paradox. The paradox is that the future lawyer is yet to be employed as a teacher. And therefore is the past lawyer who is training the future lawyer. And I used to read an article by an American scholar called Teaching Law Teachers How to Teach. Remember, law teachers are not trained teachers. The best methods they use in teaching is how they saw their own teachers teach. And that's our methods of yesterday, because they saw those teachers yesterday, and yet they are the ones we are telling to prepare the lawyer for the future. I trust you get the paradox. And today you get fantastic term papers from the average law student today. Fantastic term papers. But when you introduce an element of defense, you say, okay, once you do a term paper, you now appear before the teacher and defend it. You discover the author of the fantastic term paper cannot defend a single sentence in the paper. Do you have some thoughts on how do we deal with that dilemma? ChatGPT is giving them fantastic term papers. When you tell them, it's okay, now I've seen the paper, it's beautiful. I mean, I've not seen this at undergraduate level before. So now come before me and let's have a conversation on this paper. The eloquence in the paper does not reflect the person sitting before you. How do we get around this?
That's a tough question. Yeah, that's really a tough question. First of all, coming from a mwalimu. And secondly, because it's actually true. And we see that because I'll talk about NCIA, we have these training programs that we have for arbitration and mediation. One of the things we do is at the end of the training programs, we will give them assignments. And we will tell the trainees, please go and do this assignment or write this paper. And you are absolutely right that what will be brought is something that looks really fantastic. My view of the issue really is to have an approach that accommodates engaging with the student at the oral level before they begin to write. Before they begin to put pen to paper, let them tell us what they have so far learned, what they are thinking of then putting down in paper, and then engaging with them at that level and giving guidance before they now go to the tools on artificial intelligence, then the chat GPT, then that can produce a wonderful paper. But then the second thing is to train the student to be able to give the correct prompts that are based on their desire for knowledge, so that then when it is produced, then they have to think about it, because the truth is, you will not stop them from using ChatGPT. And they will find another app that then makes sure that it is ChatGPT 0%. So you will not catch them. And they will find another app and to be developed to beat that. So the point is, we need to use this technology, but then use it before, or rather after engaging with the learner. That's my suggestion, not as a mwalimu, but just thinking about what we've seen in practice.
I'm glad you say that. They find another app and another app. One day in a school board meeting, I kept telling my dean, when will I start being a teacher and stop being a policeman? Because what you are now telling me to do is to become a policeman, to begin policing people. And then I presume that before me are people who have some desire for knowledge, and therefore their own drive will be do the right thing to acquire the knowledge, and not to find methods of beating me at my game. Because what if after they have beaten me, they remain stupid? And that's not the desired outcome. But maybe we can go to Prof and see whether at the commission level there's thinking along these dilemmas, these ethical dilemmas with emerging technologies, and what will the men and women sitting before you, the curriculum makers, the implementers, do to make things much better? Prof.
Yeah, in this context, I usually use a line from Chinua Achebe. Chinua Achebe says, there's a little bird, and they say, I think it's called a Kalinze or something like that. Kalinze the bird says that since hunters have learned to shoot without missing, I have learned to fly without patching. This is what our students have done. They have learned to shoot without missing. We, the teachers, must also learn how to fly without patching, or the other way around, it doesn't matter. But the idea is, first of all, so I think it is a bit critical. From our perspective, I think we have to retool ourselves as teachers. We have to rethink our role as teachers. So that we, first of all, become as literate in AI as the students. Because if you are not literate with AI and the students are more literate than you, then they beat you at the game. And then you can't tell the difference. Number two is inculcate what you've just said. That the student comes to class not because they want to achieve a piece of paper that says they are first class, but they have come because they want to acquire some competencies and skills. And that includes knowledge, and that includes also the practical issue. So we must retool. And we also must change the rationale for why we educate. So that we do not become just police and trying to stop students from doing certain things. I used to teach in the university as well. These days I don't because of time, but I used to teach. And I remember having given an exam to my students one time and told them that they could use the internet. In fact, I told them I'm going to go and have a cup of tea. As you do the exam, then I'll come back and find out what you have done. And they were like that. And the idea was, I asked them, is it possible that if you go to work for a company, they will tell you, we have a problem here in this company. We would like you to help us solve it, but you cannot use technology, and you cannot use ChatGPT, and you cannot use the other. They will tell you, use whatever tools are available to you. Solve my problem. Once you solve it, then we are good to go. So if we get to that level where we are aligning our students to see, look, there are some real practical problems in society that need to be solved, and they'll be solved by people who have mastered all these things, both the textbook knowledge, AI knowledge, technology knowledge, whatever that may be. This is, I think, the fundamental shift that we need in the higher education sector, so that in your interaction with the students, it's not a policeman and the hunter and the hunted. It's as we are trying to look at a solution for a particular problem that we can do together if we master the skills that we need.
Thank you. Thank you so much, Prof, for that. For the teachers in the room, you have been told society has practical problems and there are no boundaries in solving the problem. Allow me penultimately for the panel, before I go to the pair presenters, to take us to financial literacy competences. And I'll go to you, Daktari. From your area, I'm sure you deal with the commercial arbitrations a lot. Huh? If you are to design a law school curriculum, preparing lawyers for the big market of commercial arbitration, what financial literacy competences would you recommend that be incorporated in that curriculum?
Thank you, Mwalimu, for that question. But before I answer that, let me say something I wanted to say when the Prof was discussing. I think one of the largest problem we have is, and this has been in the debate for a long time, as to whether lawyers are technicians or lawyers are aiming at justice. Are we producing thinkers or are we producing technicians? And that's a large debate that then has to go on and on, because technicians are your usual plumber. They know what the problem is. They will go and figure out where it is and clog it. If it's a conveyancing question, they know how to do the transaction, the document, and therefore we're producing technicians. So, and perhaps in the yesteryears, that is what the market demanded. But in the future years, we need to produce, in my view, intellectuals who will be able to do what Prof is suggesting. Intellectuals who think. And I've suggested somewhere in the paper that maybe we should consider having philosophy or ethics as a compulsory unit for either the CLE level or at the undergraduate level, that all students must be able to study ethics or philosophy or virtue, some of those things. So that's something I wanted to say. But back to your question, if I'm to design or to recommend designing of a curriculum in the context of international commercial arbitration, one of the things that I would really insist on is that the curriculum must address sorry about that. The curriculum must address the international landscape and the demands from different jurisdictions and what these jurisdictions demand in terms of what does an arbitration process look like. So expose the learner to what that looks like. Expose them to the different dynamics that exist in international commercial arbitration. Another component that must be factored in is the question of agency, that the individual must be aware that they are operating in an international system that requires individual agency and ability to articulate and to learn the landscape of dispute resolution. The third thing it must address, and this is really quite important, and it's a problem for all arbitrations, is the question of costs. Costs to the parties, costs to the arbitrators, how costs are computed. And because you have a party before you who is pursuing international arbitration, you need to be able to be ready to advise them that this is what you're looking at in terms of costs. You have a party before you considering an international agreement. When they are before you, you have to tell them, when you go for this arbitral institution for purposes of dispute resolution, these are the costs that you must be able to be aware of. So the learner at the earliest level, and the thing is, some of these things, Mwalimu, I picked them in the field. During our years in the 2004 and thereabout, we did not have that kind of training. These are things we picked after we have already graduated. So if we begin to expose our learners at an early stage, that at the international level, these are the conversations that are being had. Of course, from the premise of being ethical, from the promise of being virtuous, then we begin to engage at that level. That's what I would recommend for a curriculum.
Thank you. Prof, I don't know whether you have any comment on the financial literacy competences that are necessary for the lawyer for tomorrow.
I think I would not even just confine myself to financial literacy. It's just that this compartmentalization of knowledge is being challenged by almost every field. So I would say that we really have to also open up our graduates in all fields
Prof.
I think it's an indication that I mean to make it very short. But the point I'm just making is that that idea of a math-skilled graduate and someone who is able to operate in diverse fields. In fact, lifelong learning will have to be embedded in all curricula. And that means also educating yourself in various fields. Because otherwise you'll become redundant very quickly as the market changes. And you might have mastered some aspects of law this time, and you discover that actually a few years down the line, there are other aspects that you need to master. So continuous learning is going to be important, and I think openness to the idea that you are not just learning only one line of thinking. Just look at me here now. I did education, English and literature. But here now I've been put at the Commission for University Education to look at engineers and lawyers. I must be in a position to at least educate myself to be literate enough in some of these particular areas so that I can be able to have a conversation with all these professors that are coming from all fields. And I think this has to be an element that is in every other curriculum, not just legal profession.
But before you go, then this is my last question for you and the panel before I call my paper presenters is, the regulatory harmony between the Commission for University Education and professional regulators like CLE. I know it's a tough conversation. I know you may even tell me I have no instructions from the board to talk about that. But what are your thoughts? For the service providers like law schools and maybe other schools of engineering or medicine or nursing, it can be quite confusing sometimes. What are your thoughts on this?
I think my answer is I'm glad that Jack and I why is it shifting from one mic to the other? I think this is an issue that we are looking at in the context of not just legal education, but other professional bodies. And my position is simple, that if we paid attention to what we want the same thing. The Commission for University Education wants graduates that are competent, that are internationally recognized, and that have mastered all the skills that they are supposed to master in those particular areas. This is what I would like to do. When I put my signature on a document to say that that program in Kenya is accredited by the Commission for University Education, I would like that signature to bear the same weight as if it came from my good friend from the Council for Legal Education. So I think we must find a way to work together. I know that there has been an attempt, even regionally, through what people refer to as mutual recognition agreements. And here in the country, we are also working, trying to find a way to harmonize the activities of the Commission for University Education and professional bodies so that we have a common end. I think it can be achieved. It's only that sometimes we are wasting a lot of time fighting small toughs. But really, I don't think the professional bodies want a graduate who can be recognized by other regulatory agencies outside Kenya. And I don't think the Commission for University Education wants a graduate who will go to practice in the UK and they are refused entry into the country or licensed to practice in that country because they were not recognized from this other area. So we must find a way to work together, in my view. So I don't have to go back to my board. I think they have agreed that we go that direction. Don't tell them I said that here. I should know not to say such things in front of lawyers, yeah? But thank you very much. But that would be my position.
Let's clap for our two panelists, Professor Mike Kuria and Dr. Henry Murigi. They will retain their seats where they are as we invite our two paper presenters, Dr. Melissa Muindi and Mr. Paul Martin Konyango, to give us their thoughts on shaping the future of legal education, competence-based experiential learning at Strathmore Law School. I would just ask them to take the stage. 15 minutes for both of you. Yes, thank you.
Yeah.
So, good morning, everyone. It's a pleasure to be speaking today about a paper that Paul, and there's another lady called Elizabeth, and myself have been working on shaping the future of legal education. And then we are focusing on the Strathmore Law School experience and how we have been handling legal experiential learning, and then how that can be used as a benchmark, hopefully, by others, and then also what lessons we have learned and what can be done differently. So the paper has 3 parts. I don't know if... okay, yes, thank you. So actually, Paul will be the one who will give us the introduction, and then I'll come in at some point.
Thank you for that. I also want to appreciate our fellow panelists. That was a very riveting discussion. So in our paper, we are basically looking at competency-based education, and ancillary to that, we're also looking at experiential learning as a form of competency-based education and what that entails. So I will not burden this congregation with too much on definition of terms, because Prof very eruditely painted to us the picture of competency-based education as a form of education that prioritizes demonstrable knowledge as well as skills. But for purposes of our discussion, we are going to look at the 2 main approaches to competency-based education. And the first one we have is embedding frameworks, so where we are embedding CBE into pre-existent frameworks, such as the ones we have for legal education. And then the next one is on recognition of prior learning, where we are basically appreciating what a student or a learner has already covered, whether it's in working experience or perhaps it's in another course that they've done, and then how we integrate both of them. So the embedded frameworks approach is ideally one of the easiest ones, because you're bringing together a pre-existing system and also introducing the new system, which would now become CBE. There are obviously challenges with it, and part of them involve the risk in reducing complex learning abilities to something very simple, because again, we are very focused on skills. And when you look at the traditional legal education curriculum, it's very niche focused. So take, for example, theory, jurisprudence. You tend to cover a lot on the theories, you tend to cover what all these proponents are saying. Now, when it comes to competency-based, we are mostly looking at, are we having a well-rounded lawyer who can think critically, and etc. So those are some of the challenges that would be involved in a competency-based education setting. But now, this is now where experiential learning comes in, and particularly now for our paper, because under experiential learning, we are looking at what is it that law students can actually do outside there and would be of great benefit to what they are learning in class and what is also being covered in their regular curricula. And as part of that, under experiential learning, we now contend with a cyclical pattern of learning and appreciating of content, where the learner is expected to develop concrete experience. This can be through attachments, it can also be through moot courts, and then eventually they get to have a reflective observation of what they've been doing. And in that reflective observations stage, they're basically interacting with what they've seen in the field and asking themselves very concrete questions on what is it that I need to learn more to either fill a pre-existing gap or to perhaps better advance myself. And then further on, they now look at the abstract conceptualization. So from what we've reflected on, what can we do to implement it in our day-to-day activities? So that's, again, what we also factor in the paper that we are doing, and eventually how all this would lead to active experimentation. How would the students then apply these new concepts that they've acquired? And what's the value of the new concepts that they've acquired as far as their education and their overall existence as lawyers is going to be? And now, again, experiential learning as a form of CBE also meets the same challenges that are faced within CBE. And part of it is the experience they cover does not necessarily equate to learning for certain things. Take, for example, legal clinics and how they're usually undertaken. So in legal clinics, you tend to see students outside there helping members of society with their actual legal problems. And at times, what they would be covering would be niche specific, as opposed to the entire composite knowledge base of one select discipline. Yeah. And then also we see concerns on inequality. So take, for example, mooting in Kenya. Within the Kenyan legal education system, mooting is not necessarily recognized as a course unit that contributes to what CLE expects a student to cover. Whereas they will be doing mooting, competing with universities outside Kenya and Africa, who recognize mooting as part of course content. An example is Singapore Management University. Any mooter doing a moot for that particular year, they're exempted from coursework because the university has the understanding that through mooting, you're gaining actual learning experience that does not necessarily have to compare with what you're covering in class, and that becomes of value. And so, again, we are seeing these graduated challenges that we experience in CBE now arising in experiential learning. But does that mean that it's not a tenable process for us? As far as our legal framework is concerned, we all know that we moved our education curricula from the 844 system to the system we now have, the 26333. It has a number of stages. Yeah. So because we've moved our system there, then the question arises, how about legal education? What happens post-high school? So as far as we are concerned and our regulatory framework is concerned, the legal education regulations provide for experiential learning, but only as a measure of recognizing professionals who have worked in the legal field for 10 years. It's not yet inculcated into undergraduate studies and undergraduate programs. And that's now where what we've been doing at Strathmore comes in as a way of how we've gone about implementing experiential learning into the undergraduate program. And with that, I'll invite Dr. Melissa to continue. Yeah.
Thank you. So this is the part where now I get to talk about what Strathmore has been up to. And where I'll begin is that since around 2018, we had already had discussions about having a course on legal experiential learning where students who take part in different components such as mooting, law clinic, and law review would then get recognition for that. So it was actually embedded into the curriculum in 2018, but wasn't actualized until about 2-3 years ago when one student actually came forth and said, she had taken part in a number of international moots and wanted to be recognized for that, such that she would do one less elective, and there was provision for that within the curriculum. So after that, we're like, okay, now we need to set up the framework for that. So we have a course called Legal Experiential Learning, which now in the most recent curriculum that we have, the 2023 one, at least has a proper structure for it. Now, how it operates is it's treated as an elective unit, so it's not compulsory. And as I mentioned a couple of years ago, it was just one student who actually took us to task with the fact that it is in the curriculum document, can she get credits for experiential learning? And now the numbers have gone up. As of this year, we have about 25% of the fourth-year students who have taken that option. Now, through these elective course units, students can get academic credits for their involvement in moots. Now, if a student has taken part in an international moot competition, then because of the amount of effort that it takes for them to prepare, actually some of them spend up to about 100 hours in terms of preparing for the competition. So then that is equated to 3 credits. So it's the same as any class unit that they would do. And if it is a regional competition, then that would be 2 credits. If it is a national or local moot competition, then that would be 1 credit. So there's a possibility of mix and matching within this framework. And then for law clinic, So this is where the students engage with the Strathmore Law Clinic. And they get to do different initiatives in terms of helping the community, doing legal aid. Recently, there was a legal aid caravan. So where a student has taken part in the law clinic for 1 semester, then they can get 1 credit towards legal experiential learning. And so they have to take part in more than just 1 semester. And then for law clinic, there's extra marks that would come when you have a leadership position. So that is an incentive to the students to actually take on beyond just being out there in the field and providing their services under the guidance of an advocate. If they take up a leadership position, then it counts towards something. And then the third alternative is through the law review. So this is where there's recognition for the publishing efforts that a student may have done. So this may be either that they have published academic papers, or being involved in publishing a book, or being part of the editorial team within the Strathmore Law Review. So in this way, students get to tap into practical ways of engaging with the law outside of their regular classroom experience, and they get credits for that. So it's one of the things that's still picking up, and I'm happy that students are tapping into that space so that then they can get knowledge in a different way and learn law in a different way. And the practical impact of that is that now in 4th year, 2nd semester, instead of doing 6 elective units, then they do 5, and then the initiatives that they would have taken part in from 1st to 3rd year are then given credits, academic credits. So that's the main one. And in addition to that, there's also other experiential learning initiatives, one being attachments. So between 1st and 3rd year, all through, the students are involved in attachments. So after 1st year, there's service-based learning where they do 225 hours of community service. And at the end of 2nd year, there's judicial attachment. So this is, the standard judicial attachment that all law students do. And then at the end of 3rd year, there's work-based learning, where for 320 hours, the students are supposed to provide their services in a law-based institution. So it can be a law firm, but it doesn't have to be. It can be even a legal office in a company, so that they get practical experience to apply the skills that they have been learning in the classroom. So these are just some of the initiatives additional to the elective unit on legal experiential learning. And in addition to that, there's also aspects of experiential learning through the research centers that Strathmore Law School has. So we've got a number of research centers housed under the law school, one being the Strathmore Dispute Resolution Center, there's the Strathmore Tax Research Center, there's the Strathmore Center for Law and Policy. There's now CIPIT, which has outgrown the law school and is now an independent research center. That's the Center for Intellectual Property and IT Law. And the good thing of having research centers within the law school or affiliated to the law school is that students can get to intern at the research centers, and in that way get to interact with the law in a more research-oriented way. And so in that way, they can learn things beyond what they learn in the classroom in a more practical way. So those are just but some of the initiatives that we have been playing around with at Strathmore Law School as we are trying to prepare for CBE. We know that we probably will need to do a lot more to be ready for the CBE students who are joining us in the very near future. Anyway, in terms of recommendations and conclusions that are highlighted in the paper, so we've talked about the regulatory enhancements that would be needed. And one, if we are to fully go in the direction of legal experiential learning, there would need to be adjustments in terms of recognizing experiential learning as a core. I want to open it on my phone so I don't have to keep turning back. As a core legal education component. So having express recognition of these experiential learning components within the curriculum would one of the things that would be helpful, and having it possibly as a requirement for graduation would also be useful. And then also in terms of assessments, that's one of the things that would need to be considered, how to develop ways in which these assessment of practical components can be done in the best manner possible. Possibly thinking about recognition of prior learning within the law context. We have not yet done that within Strathmore Law School. I don't even know whether the framework, allows for that yet. But there's thought in that direction. How can we have recognition of prior learning frameworks within legal education? And then aligning legal education standards with CBE implementation. That is something that we need to do in the very near future. And finally, possibly recognizing experiential learning infrastructure in the accreditation criteria, so that then, even when it comes to accreditation, can this be one of the things that is looked into when determining whether a law school is on track? My final slide is just saying that, as Strathmore, we are trying to see how experiential learning can be integrated into the existing regulatory framework, bringing in some level of creativity. However, full institutionalization across the Kenyan legal education framework demands regulatory reform. So to be able to take it on fully, and one of the things that's done at a national level, there may need to be reforms that are thought about, and embracing these reforms would enable the Kenyan legal education system to produce graduates with practical skills, the skills that the panel was talking about, future ready for the 21st century practice. And I will stop there, unless Paul wants to say anything as final comments.
Thank you. Thank you so much. Let's clap for Dr. Melissa Muindi and Mr. Paul. Dr. Melissa Muindi is the academic director at the Strathmore Law School, and Paul is a graduate assistant at the Strathmore University Law School. And I think this is real information, particularly for those of us who are in the legal academy in this room. Good people, my role as program director was to manage time. I have spent 62 minutes out of the originally allocated 90 minutes. So I have saved some 28 minutes for the rest of you here. To wind us off, before you leave that stage, I want to call Prof. Winnie Kamau to step forward and hand over the gift packs. Prof. Winnie Kamau, is she in the room? Thank you so much, Prof. Karibu sana. Who is helping Prof to hand over the packs? So we'll start with those on the stage. We'll start with Dr. Melissa Muindi receiving her gift pack. I hope the cameramen are here and ready. Thank you. Thank you so much, Daktari, for that. Then we'll have Mr. Paul Konyango. Thank you, Mr. Paul Konyango, step forward. Thank you. As that happens, I will ask Dr. Henry Murigi to move to that place and take his gift pack. Prof, before you go, there's one more recipient of the gift pack. Thank you. Thank you. Prof. Mike Korea had an engagement elsewhere. He stepped out. His gift pack will be handed over much later. And now I want to go back to CLE to take over this microphone. Thank you. Thank you so much, Bwana Ogada. Karibu and take over duty. You have 1 hour. You can take 45 minutes and save these people a lot more time. Thank you so much. Karibu sana. And you can clap for me also for managing time well.
Mwalimu Ngoya and I have been on duty. He leads and I follow. We can do better for Mwalimu Ngoya. The general from Musingu is here, Nelson Harvey, and he executes. So when we give orders, you execute. We said you clap the Moi way. Si ndio? Moja, mbili, tatu, funga, fungua. I'm told that the chief guest is around here, and she will be joining us soon, and that is none other than the Chief Justice and the President of the Supreme Court. She will be stepping in any time from now. As we wait, is there any burning question? Oh, before any burning questions, did Mwalimu Ngoya get his backpack? He was issuing backpacks, and yes, we need to give Mwalimu his backpack. And then we clap for him because Mwalimu has done a good job. Moja, mbili, tatu, funga, fungua. Professor Sihanya, I will ask you to hand over that bag to Mwalimu Ngoya. Professor Sihanya taught me constitutional law, so when I cause all the ruckus, all the goods are attributed to him, all the mess to myself. Professor, asante sana. He also taught Mwalimu law and development.
And we appreciate all of you. So many current, former students, grand students.
Thank you very much. Asante sana. Thank you very much, Mwalimu Elisha Ongoya. So, I was about to ask, is there any burning question? Any burning question? I will do two. One lady, one gentleman. There's a gentleman from yesterday next to the incoming president of the LSK, Charles Kanjama. Good morning, sir. There's a gentleman, he had a question from yesterday. We didn't take it. So, sir, you will pose your question now. Gender parity and equality. Do you have a lady? A lady posing that question. Yes, I see one there. Short and sweet as we wait for the CJ. Sir, your question first, then we go to the lady behind. And you identify the panelists you want to take the question.
Thank you so much. My name is Charles Muitui. I'm the Dean School of Law, Kisii University. My question is directed to the presenter called Sewe. I don't know whether he's here this morning.
Sewe is here.
He indicated that we need to be equipped with the skills that require somebody to have sufficient knowledge in technology so that we can be able to know what is money laundering and how it is done. And that in order for us to conduct an effective cross-examination, you need to understand these concepts. Now, the question that I'm asking is this. According to me, it looks like this is a complex area that requires somebody to undertake detailed knowledge, to have detailed knowledge, or even undertake a degree in ICT in that relevant area. The question is, how can a lawyer, somebody undertaking an LLB degree for 4 years, be able to combine that with that complex area in technology? Thank you.
Okay. Mr. Sewe, I saw you around. Where are you? Okay, you've heard that question, eh? Santi sana. Thank you, Mr. Sewe. The lady behind.
Yeah, thank you. I just wanted to ask the presenters from Strathmore Law School, is it possible to fail experiential learning? That's it.
Is it possible to fail experiential learning? We start with Mr. Sewe. You give us your response, then we go to Team Strathmore, led by Dr. Mwindi.
Hello, thank you so much for the question. Yes, my name is Wycliffe, and I'm serving as the blockchain forensic specialist at AND Forensics. Yes. Based on the question which you have asked, whether someone needs to have expertise in ICT skills, ideally, that's not always the point. I know for the longest period of time, there is that myth and misconception that in order for you to understand how virtual assets work, in order for you to understand the basics of evidence collection within the blockchain ecosystem, you need to be a tech savvy. But ideally, that's not always the case. And this is brought from the fact that whenever we take through law enforcement teams from the prosecutors or DPPs. We normally try as much as we can to break the concept down to a way they can be able to understand and integrate to their day-to-day normal operations. You don't need to go and take the ICT classes, but during the trainings, once we get to understand the target audience, we try as much as we can to make it in a way that you'll be able to understand from the basic level, and then based on the knowledge which you have gathered from the legal area, you can just be able to combine and amalgamate it in a useful way. I believe that answers your question. So it's not technical. I know the names which maybe probably popped out yesterday sounded a little bit more technical, but I can guarantee you it's not as technical as you may think. Thank you so much. Santi.
As we wait for Tim Strathmore, probably Mr. Sayo, you'll help me understand this later. There's a colleague who has paid fees using bitcoins, 43,000 shillings, and he has been hauled to court by the DPP on the basis of this law called Pokamla. You will give that answer to myself and my brother here, Majimbo, understand later. Tim Strathmore.
Okay, thank you.
I'll even just pick the same microphone. So in terms of the legal experiential learning elective course unit, it's not possible to fail. The way it's currently structured, and that's why it's an elective course unit, students opt in. So since MOOTS, law clinic, and being part of the law review are not compulsory, if a student is interested, then that is a way of giving credit to that interest and recognizing the effort that it takes to even take part in those initiatives. However, when it comes to the attachments that they do, that is service-based learning, judicial attachment, and work-based learning, there is the possibility of failing if, for example, the student doesn't do the attachment, because those are compulsory. So if they don't submit their report, if, let's say, they signed up for the experience, they don't show up, they get a negative report from their host supervisor, there is the possibility. The likelihood is very low because since they know that they are being graded when they are on attachment, they actually go the extra mile. So most times, even as faculty, when we go to supervise the students when they are out on attachment, we find that they are the ones who are asking most of the questions and asking for more work, so that when they are supervised, then they can get their straight A, because that is the easiest way for students to get an A. But for legal experiential learning, no, they don't fail, but that's because they opt in. So only those who want to take part in MOOTS or law clinic or law review sign up. And since it's not compulsory, those who feel that that is not their strength, then don't. Maybe if one day we make it compulsory, then that would be one of the challenges that we might face. Thank you.
Thank you very much. We can give the panelists a hand of applause. This is where we fail instructions. What did we agree? Kanu and Moi. Moja. Funga. Fungua. From the room, you can tell those who were born in the year 2000. When Mzee Moi left us, this corner here. You grew up when Mzee left us, and Mzee used to give us free milk. And when he spoke, you rose up and did what he said. Thank you very much. Now, we're still waiting for the CJ. And as we wait for the CJ, allow me to recognize the presence of the former president of the Law Society of Kenya, the General from Musingu, my good friend and elder brother, Nelson Andai Havi. Santi sana. Thank you very much, sir. Then we have the incoming president of the Law Society of Kenya, my good friend, Charles Kanjama, senior counsel. Welcome, sir. We have the dean of the newest minted school, Tom Mboya University, Agwings Kodek School of Law. Professor Omwara, welcome, sir. I saw the Dean Southwestern, Ambassador Koki, she's somewhere here, Karibu Sana Dean. We had the deputy, the CEO, the acting CEO for Council for Legal Education, she's also here. We will be given the protocol as soon as Professor Mwimali lays it for us in a few minutes. Ladies and gentlemen, I don't want to bore you any longer. I will take a break here as we wait for the CJ. DJ, tafuta ngoma ya maana ya kuchangamsha hawa watu as we wait for the CJ. Muna rumba hapo? Mimi ningeitisha reggae. Tafuteni rumba. My good friend Nelson Harvey is here. So mumtafutie rumba or anything that you can play as we wait for the CJ. Santi. In the meantime, get to know your neighbor. Get to know your neighbor. Jua jirani ni nani. Shake the hand of your neighbor. Get to know who they are. I have received the signal from Director Mwalimu Konuche that our guests are coming. Now that the guest is coming, please let's be up on our feet as we welcome the Chief Justice of the Republic of Kenya. And we are doing the Moi clap. Huh? We do the Moi clap, the legacy is another thing. So let's welcome our chief guest today, the Chief Justice of the Republic of Kenya, the President of the Supreme Court, Honorable Justice Martha Koome. Moja, mbili, tatu, kufunga, fungua. You continue until she sees, huh? Tuendelea. Asante sana. Welcome, Honorable Chief Justice. Thank you very much. We may take our seats. Without further ado, allow me to welcome on stage the CEO of the Council for Legal Education, Professor Mwimali, onto the stage. Professor, karibu.
Thank you very much, Mwalimu Ogada. Your Ladyship, Honorable Martha Koome, Chief Justice of the Republic of Kenya and President of the Supreme Court, Professor Collins Odote, Chairperson of the Council of Legal Education, Mr. Francesco Chechi, the Team Leader, UNODC Anti-Corruption Hub, Professor Mike Kuria, I think he was here in the panel and has stepped out, the CEO of the Commission for University Education, Dr. Pamela, the Director, Law Development Center in Uganda, Council members of the Council of Legal Education, Mr. Nelson Harvey, the former President of the LSK, Mr. Charles Kanjama, SC. We have law faculty representatives. We have the chairperson of the Kenya Law Reform Commission, Mrs. Agimba. Members of the Senior Council Bar that are present. Representatives of the Fourth Estate, all the key players in the legal education sector that have been invited. I see a number of deans of schools of law seated. Distinguished ladies and gentlemen, we are delighted this morning to host the Honorable Chief Justice. My lady, it is a distinguished honor on behalf of the Council of Legal Education to welcome you to this conference I think it's something that has been an ongoing discussion. We started these conversations yesterday, and one of the things that arose is these are discussions that started way at the time of independence of Kenya. There was a commission, the Law Dealing Commission, that looked and reviewed the future of the legal profession and practice in Kenya. And since then, these concerns have been overarching. We are hoping that for our generation, we'll have a session where these discussions then would lead to concrete solutions and ideas of how the future of legal education in Kenya would be. There have been quite a number of debates, my lady, the debates around the number of advocates that are entering the market. There has also been questions about the quality of legal training and the ongoing reform in terms of how we examine at the bar. We have concerns about the undefined paralegal career pathways, all of which require urgent attention and harmonization. We have also issues of globalization and financial systems that have been a major concern that need to be addressed in the way law is taught at the current level. My Lady Chief Justice, the Council of Legal Education is committed to working collaboratively with the universities, with professional bodies, with the judiciary, with the regional councils, and the development partners to safeguard the standards and promote innovation in legal education and training. We place special value on the voices of students and young lawyers as co-creators of the future of legal education. My lady, we specifically welcome you to the conference as the chairperson of the National Council for Law Reporting and also the chairperson of the National Council on Administration of Justice to buttress that effort of interagency collaboration in addressing these myriad problems that we encounter in legal education. So, my lady, permit me to welcome you to this conference. I know you have other busy engagements, and we are honored that you are able to make time to join us. With those remarks, permit me to invite Professor Collins Odote, Chair of Council, to make his remarks and welcome you. Thank you.
Thank you very much, Professor Jack Mwimali, the CEO of the Council. Your Lady, the Chief Justice of the Republic of Kenya, and the President of the Supreme Court, a very, very dear friend, Lady Justice Martha Koome, the team lead, UNODC Anti-Corruption Hub, Mr. Francesco Cecchi, the CEO of the National Council for Law Reporting, Janet Munyoki. I must declare that we actually took Jack from the National Council for Law Reporting, but I was telling Janet, our gain is her gain too. But we're also laughing with the Chief Justice about something else concerning that taking. Please allow me to adopt the protocols that have been laid very ably by the CEO and thank all of you for coming on the second day of this conference. Your Lady, the Chief Justice, this conference is titled the Inaugural Conference on the Future of Legal Education and Training in Kenya and the Region. Yesterday at the opening session, I made several statements. First, that this conference is coming 66 years after a conference again at a very critical time for the continent on the future of law in Africa, when a lot of African countries were getting independence and we were starting to ask ourselves, what kind of law do we need to train? What kind of law do we need to practice? What kind of law do we need to experience in the country, in the continent? In 2025, similar conversations are necessary. Your Lady, just a few minutes ago, we were having a conversation and you were talking to us about the conference taking place just here that you're hosting. And where one of the conversations is about multi-door and multi-approach to justice, making the point that 90% of justice claims are dealt with outside courts. Therefore, what does that mean for how you engage with those processes. A very critical conversation for us here, Chief Justice, because it also asks the question, what does it mean for how we train? Do we train people for the 10% or do we train people for the 100%? And if we train people for the 100%, how do we conceptualize our curriculum? In the conversations that just took place before you came, we had a presentation from the Nairobi Center for International Arbitration, who was then saying, should ADR just be one case, one unit out of the 30 plus, when 90% of cases go through ADR? I think something for us to be able to think about. But Chief Justice, also yesterday, we had conversations as part of reimagining those future about whether our focus in legal education should be on regulating the quantity of lawyers that come into the profession or regulating the quality of lawyers that come into the profession. I say so because you and I have had the flack, yourself as Chief Justice, because you admit everybody who becomes an advocate in this country, and we examine everybody who becomes an advocate. So when 920 of them are admitted, as they were a few weeks ago, the uproar that comes from the profession, which is represented here by Elisha Ngoya, Charles Kanjama, Nelson Harvey, and co, will then say, but there are too many coming into the field. And this too many is flooding the market. And we must respond and ask ourselves, is that a legitimate concern? What can we do about it if it's a legitimate concern? Because on the one hand, we must balance from the fact that everybody sitting here, or at least the majority sitting here, have children. Those children go to basic education, they go to university education, they dream of having a career. Those 920 that we admitted dream of becoming lawyers, as we all dreamt many years ago. What's the best balance between ensuring we have quality professionals and we don't defer people's dreams through an artificial process of blocking them? I think a conversation that we must have as part of the future of legal education. Should our focus be on quality or quantity? And how do we ensure we continuously improve the quality of legal education? Yes, it is admitted there are concerns about the quality of legal education. But as we have those concerns, we also must recognize that those concerns are not unique to Kenya. As our friend from the Law Development Center told us yesterday, Uganda is currently grappling, your lady Chief Justice, with similar issues. Do we decentralize the Law Development Center? Do we separate training for examination? Conversations we had when we separated Kenya School of Law from CLE, similar conversations. But as our colleague from UNODC also told us, the quality of lawyers that we produce and that they hire are satisfactory to them. So even as we talk about improving, let us admit in where we are also doing well, so that we are not throwing away the baby with the bathwater. Conversation number 3, Chief Justice, that we also had yesterday, and we continue to have, is how do we improve access to justice? Your lady, the Chief Justice, when you came in, you launched STARGE, Social Transformation Through Access to Justice. As the Council of Legal Education, our vision is innovative legal professionals transforming society, meaning that the role of lawyers goes beyond the courtroom. The role of lawyers must be a catalyst in how we transform the society that we live in. So how do we improve the training to help lawyers recognize that law is not in Nairobi, law is not in Kisumu, but law is in Asumbi, law is in Chogoria, and law is in Kapenguria, in all parts of this country, so that we are able to ensure that everybody has access to justice, not only those in the urban areas. A critical conversation, how we train and what we train. Chief Justice, we also had a conversation about technology. Yesterday in the afternoon, we were being shown about the fact that while today you have a bank account with names, because of developments in technology, the kind of cases that we'll require to engage with and that will come to you will have wallets, will have signs. So you require a lawyer who is not single discipline, but a lawyer who is interdisciplinary, who appreciates technology so that they can be able to use that to practice law much more effectively. But we also warned ourselves that technology should not replace our brains. we should not, as students, use ChatGPT only to answer assignments and then be unable to defend them before Teacher Ongoya. We should not, as legal researchers, use technology only to prepare drafts for our judges. But we should also, as judges, not use technology only to prepare judgments. Technology should help us, not replace us. But that asks us the question, how do we train ourselves to be able to ensure that technology does not replace us? How does, and Elisha posed the question today, how does a lawyer who never used a computer train a future lawyer who does not use a computer anyway? When I tell my daughter about Facebook, she tells me, Dad, but you're too old. So how does a father who thinks Facebook is social media train her daughter who TikTok is old school? They use something much more. So I think we also must unlearn to learn so that we train future lawyers much more effectively. Lastly, CJ, so that I don't speak for too long, we've also had a conversation supported by UNODC about the place of integrity, the place of the fight against terrorism, and the fight against corruption, anti-money laundering. As lawyers, we must balance between our professional responsibility to our clients and the larger responsibility to justice, so that professional ethic, professional client confidentiality does not become a ticket for ensuring that we get accused of being involved in money laundering. And how then do we balance those are critical conversations. So we're extremely glad, Honorable Chief Justice, that despite your very busy schedule, as the person who consumes all the people that we train, as the person who is in charge of the justice process, as I'm the chair of the National Council of Administration of Justice, you're here with us to share your reflections and to help us chart a future for the legal education, a future that shows that law is central to society, but that law is dynamic and innovative. With those very many remarks, let me thank you and also invite you to address the audience. Please, a round of applause to the Honorable Chief Justice as she comes in. And we could stand the Obama clap until she comes.
Thank you very much. Please, may we be seated. Thank you, my professor, Professor Ondote, for those very kind remarks. Let me abide by the protocols that have been established and say I recognize all of you present here this morning. And if I may enumerate or copy a friend in the judiciary who says, I fear you all. Indeed, I'm honored to be in your presence this morning. Friends, people we have worked together, people who appear in our courts, and people who robustly engage us as a judiciary. So a very good morning to you all. Habari zenu. Salamu alaikum. Yes, thank you. Thank you very much. Thank you also, Mr. Francesco, on behalf of the UNODC. We appreciate the support you have given CLE to hold this conference. So this morning, I'm honored, indeed most honored, to join you for this important national conversation on the future of the legal education in Kenya and also in the region. Like I have heard that you had presentations also from Uganda. So I really commend the Council for Legal Education and UNODC for convening this conference, which speaks directly to the needs and aspirations of our legal profession at a moment of profound global transformation. This conference is absolutely opportune because it's only, I think, a week ago when we were grappling with the negative social media that was directed to me and CLE, I think Professor Mwimari, who was present, and to stand up and declare that it is indeed right for us to admit the 920 newly admitted advocates whom we admitted, and declare that we have no apology for doing so. And I also restated the same statement that as the Chief Justice, I looked at all the papers that were presented. Those 920 newly admitted advocates were trained, were tested, were examined, and they were found to be fit to be advocates of the High Court. But because we fear social media, my people were like, can we divide this into two so that we admit some now in November? Then I asked them, and what do we do with the others? And what justification do we give for dividing them into two? Oh, the next admission will be in March next year. Why should we keep somebody away from becoming an advocate, becoming a professional, and taking part in making a living as a professional simply because we fear social media? I told them we will admit all the 920 because we have no justification to own anybody. In any case, when I look at those who are attacking them, they are at the pyramid. It's a pyramid. They are happier. They are on the apex. They went to the same universities. They qualified. They practiced as junior lawyers. Now they are senior. Why are you fearing juniors? You are up there. Why are you fearing people who are entering the profession? So now that I'm listening to Professor Ondote this morning, I know the problem is with the quality of education. If that is the problem, that's a problem, then we address it. But we can't throw our babies with bath waters. These are our children whom we have taken through basic education, secondary, tertiary, school of law, professional training, and we cannot be gatekeepers because we became. So we cannot stop the others from becoming. So that is a conversation we had last week, and then I received a letter inviting me for this engagement, and I said this is absolutely opportune for us to come together, all of us, and discuss and find out how, if the quality is the problem, how can we address the problem? But we can't come into the way of the life of the young people who want to become lawyers, who want to become advocates, and block them and tell them we have so many. Immediately I did that admission, I was invited in India to attend the inauguration of their Chief Justice and also the celebration of 75 years of the Indian Constitution. And what amazed me about that country, because we were several Chief Justices, including some countries I've never heard about, Buddhistan, a Chief Justice was there, and he said he has seen more lawyers than the people in his country because the population of his country is 700,000 people. They are not even 1 million. But India has 1.4 billion people. And the number of advocates looked like there were 1 million because they all came for that celebration. So why are we fearing 55 million people when India is dealing with 1.4 billion people? So this is a societal problem that we are trying to look for technical problem for, to to say stop lawyers from studying law, from joining the profession, instead of looking at the real problem. The real problem is perhaps the quality, and is perhaps opening opportunities for these lawyers, not to just be traditional lawyers that I have been or was, and many in this room have been, but opening opportunities for them in many, many areas. So this conference, for me, comes at a pivotal moment, one where our country and even our region, like we are discussing next door, and even the whole world is confronted with unprecedented shifts in governance, in technology, in economic integration, and transnational nature of crimes. Those are areas that we really need to look into seriously and see how we can sharpen the skills of the lawyers we are training also to go into those areas. In this context, the role of lawyers is changing, the demands on our judiciary are evolving, and the expectations of the public are rising. Consequently, legal education must respond effectively to these demands. Dear colleagues, in addition to ongoing regional and global changes in Kenya, and increasingly across the region, the conversation about justice is also undergoing a profound shift. We are moving towards a people-centered approach to justice, an approach that puts the lives or the lived realities, the needs and the aspirations of individuals and communities at the heart of justice. What the people-centered approach to justice means and how it can be realized is that justice is not only found in the courtrooms. Justice is found, it's a lived reality, it's a common good. It is found in our families, in our communities, in the marketplaces, in the places where we worship. And therefore, this cannot just be realized without having judges, judicial officers, and lawyers who are able to adapt, who are knowledgeable and committed to furthering the ends of justice that becomes a lived reality in the lives of our clients, the people who come to us, and even empowering those people to know their rights and know how they can deal with issues that confront them. In other words, how can everybody, because everybody wants to experience fairness and justice, how can everybody become a champion for justice? So the formation of such a judge or a judicial officer or a lawyer begins in the classroom where they are taught. And this is where CLE and our universities come in handy, because I think we have to change the approach that we use so that we can refine our curriculums to fit this kind of a calling. If we are to take a step back and reflect about our legal education in Kenya, and indeed the entire East Africa region, we can all agree that tremendous progress has been witnessed. From a handful law faculties at independence to diverse ecosystem of law schools that we see today. We have seen expansion in terms of access to legal education. We have seen also specialization grow and the entry of new areas of teaching and practice of law. As a matter of fact, when I was admitted as an advocate in 1987, when many of you were not born, I was number, I think 1,700. Today we are over 27,000. I alone as the Chief Justice have admitted about 10,000, more than they were. Many decades. You can imagine the admission of lawyers from independence up to when I was admitted, it was 1,700. And you can imagine I've been Chief Justice for 4 years and 6 months, and I've admitted 10,000. So this is really exponential growth that we must appreciate, celebrate, and find a way of accommodating them. Because this growth is not a curse. Is embracing. However, it has brought with it some complexities that make us sit here at this conference to address. But there are equally opportunities and challenges that you will be grappling with, but I believe the solutions are with us. The world into which we are training lawyers is today vastly different from the one that I was trained or that was contemplated when many of us were trained. Globalization has accelerated the mobility of commerce, capital, and people and ideas. Digital technologies have transformed how justice is availed and accessed, how crime is committed, and how evidence is gathered. Equally, regional integration under the East Africa Community and the African Continental Free Trade Area has expanded cross-border commercial transactions, creating new frontiers of opportunity, but also establishing new layers of vulnerability. This is why Professor is talking about us imagining the future all the time. And as we imagine the future, we imagine the opportunities, and we also imagine the challenges that come with that future. This expanding universe of opportunities and challenges require lawyers who are agile, who are globally literate, technologically fluent, ethically grounded, and capable of navigating the legal systems that intersect across borders and jurisdictions. Indeed, today's lawyer must understand not only the law, but the ecosystems within which the law operates. Increasingly, complex financial crimes such as money laundering, terrorism financing, and cybercrime call for competencies in financial intelligence, risk management, compliance frameworks, cybersecurity, and digital forensics. Cross-border transactions also demand proficiency in international commercial law, trade investments, protocols, and arbitration. The theme of this conference, Legal Education and Training for the Globally Competent Lawyer, reflecting on the past and charting the future, therefore invites us to take stock of where we have come from, while boldly imagining where we must go. It demands that we recognize that the next generation of lawyers will not be defined merely by professional credentials, but by their adaptability, resilience, and capacity to address problems in a world where change is constant and complexity is the norm. From the judiciary's perspective, the future of legal education is deeply intertwined with the future of access to justice. Our blueprint, the social transformation through access to justice, calls for a justice system that is people-centered, that is responsive, that is technologically enabled, and that is grounded in multi-door approaches to dispute resolution. Colleagues, next door, we have a convening of about 500 judges, judicial officers from the East Africa community converging here in Nairobi to explore how we can use the multi-door approach as a means of accessing justice for our people. Under Article 159 of the Constitution, we are mandated to promote alternative forms of dispute resolution. And as you know, the judiciary is carrying up court-annexed mediation. Indeed, we are now at 46 counties having registries for court-annexed mediation. We are also scaling up the alternative justice system. This is an organically grown program where we are helping communities to resolve their own disputes. We've already established NJS suites and forums in 13 counties. It's a very labor-intense program of training people on NJS because we have it rooted in our African customary laws. We knew how to resolve our disputes in many communities, but as you know, unfortunately, when we were colonized, our systems were declared repugnant, and therefore we were forced to adopt common law. We've been struggling with this common law. Next door, we were told the developed world has adopted the alternative ways of resolving disputes. As a matter of fact, we were told in the United States of America, 95% of their disputes, including criminal, are resolved through the alternatives. It's only 5% that go to the formal justice system. And they learned about mediation and alternatives from us Africans. But how come as we have stuck on the common law and we have discarded the alternative that made sense to us? So what we are doing under AJS is to train our mediators or our negotiators or our ukumbi, we call them ukumbi, but you can call them tribunals, on the fair trial imperatives. We are training them on the constitutional minimums, that if you are forming an ukumbi or a tribunal, it must be inclusive. You must have men, women, the youth, persons with disability. That is one imperative that was not applicable in many of those tribunals before, especially the one where I come from. We call it Jurinchekwe. It was a club of men and old men, for that matter. So what we have told forums like those, you have to be compliant with the Constitution so that we can work with the judiciary. So because it's labor intense in terms of training and organizing them and getting them into a system that is credible, that we can check their quality of the justice that is being delivered there, it's taking a bit of time. I could not sit in Nairobi and say I've launched NJS in all the counties. We have to go to every county, engage with them, train them, and the committee that is led by a Court of Appeal judge, Professor Justice Joel Gogi, is doing a great job. It's a multi-sectoral committee that includes very, very vibrant members from LSK who have been helping us in this respect. The other way of scaling up the alternatives is the small claims courts that are doing a good job to access justice expeditiously to people with the small claims. The turnaround period there is about 60 days, and we have found very, very many people accessing justice through the small claims courts. We now have 40 of them. A Judicial Service Commission is recruiting about 100 resident magistrates, and about 40 of them are going to be deployed as adjudicators in the small claims court. So we are increasing the capacity of that court. The other one is the specialized courts that respond to the needs of the modern society. There we were being celebrated for having the only court that deals with environment and land issues. That is a specialization that is also adopting these alternatives to help people resolve very emotive land issues. We also have the gender justice courts for those who care about the endemic, systemic problem we have in this country of gender-based violence. And for us in the judiciary, these reforms are creating new opportunities also for lawyers in Kenya and across East Africa to sharpen their practices. In this emerging landscape, a globally competitive lawyer is not the one who just understands the law, but one who understands society, technology. Like Professor was talking here, I could not imagine the lawyer you are envisaging who does not use technology. They will find it very difficult to file, to do e-filing, to do virtual hearings, to do case tracking system. Therefore, technology is part and parcel of these games. We also need to understand markets. As lawyers, we need to understand human behavior and changing dynamics of justice. Therefore, our legal education must prepare lawyers who can successfully navigate these complex dynamics while upholding ethical standards and enhancing access to justice. As we reflect on the past, we must also confront systemic challenges that the legal education in Kenya and the region has been facing. There are gaps in curriculum coherence. There are challenges in pedagogical innovation, inadequate integration of technology, and a persistent disconnect between academic training and practical realities. Importantly, ethical formation remains an area that requires greater intentionality, especially in a world where corruption, shortcuts, and unethical behavior threaten public confidence in institutions of justice. The judiciary encounters the consequences of gaps in training, professionalism, and ethics every day. This conference, therefore, is a platform for enhancing clarity, alignment, and shared resolve in addressing these challenges. There are also remarkable opportunities before us. With a growing digitization in our courts and also in the legal profession, we have a chance to embed digital literacy at the foundation of of the legal training. With the rise of artificial intelligence and automation, the legal profession can evolve to focus more on analytical, humanistic, and relational competencies. AI should not threaten us because it cannot take part in understanding the background, the context within which we work. It cannot replace empathy and care. Therefore, as you engage in this conference, I encourage you to imagine a future where legal education is interdisciplinary, where legal education is technologically empowering. It is experiential in nature. It is ethically anchored and globally connected. A future where law schools, professional regulators, the judiciary, the industry players, and international bodies collaborate to shape a holistic lawyer. Recently, the Supreme Court took the challenge when we hear that the universities are producing half-baked graduates. We asked ourselves, how can we come in to support and mentor students from the universities? And for 2 years learning, we've been doing a moot court by the Supreme Court where we call the law schools to bring students to debate. And the last debate, which happened only a month ago or 3 weeks ago, was on very complex international issues. And the way I saw those students robustly debating, arguing their cases, the memorandums that they prepared, I am so confident that the universities are doing a good job, and we commend you for that. So let also the private sector step in and see how we can help the universities mentor and sharpen our students. So as I close, I urge all of us to embrace a bold and collaborative approach to reforming our legal education. Let us commit to strengthening quality assurance mechanisms, modernizing our curricula, integrating practical skills and ethical instruction, expanding clinical programs, and establishing stronger bridges between academia, the judiciary, the industry, the bar, and everybody who cares about having a legal profession that thrives. Let us place integrity at the heart of training, for no amount of knowledge can compensate for the absence of ethics. Importantly, let us remember that in shaping the next generation of lawyers, we are also shaping the future of justice in Kenya, in the region, and beyond. I thank you all for your attention, for inviting me, and I wish you very, very robust and successful deliberations. I don't know whether I'm supposed to declare this inaugural conference open, but if I'm not, I am, let me do it and say that with your kind permission, I declare this inaugural conference on the future of legal education and training in Kenya and in the region officially opened. God bless you.
I see we did not get the instructions. That's not how you clap for the Chief Justice of the Republic of Kenya. So can we do it again? Moja. Mbili. Funga. Fungua. My brother from the photography section, and I see the associate member of LSK, Mr. Zakim as well, is here. You're going to guide us on how to take photographs with the Chief Justice. So we're going to do the chair, CLE, council members, the representative UN doc, the CEO, and after that, the deans that are present. I think we're going to do it here. Downstairs? Yes, I'm told it's downstairs. The photographer, we do it here. Okay, I've been countermanded. So we will humbly request the Chief Justice to join us on stage. Professor Odote, the UN doc representative, Professor Mwimali, fasts. Yes, CJ. Okay, that's Mr. Zakim's forte. I will not interfere. He's better than me, and he's an associate member of the LSK. Then next, I will request that the deans present, council members, not council members, but members of the CLE board also join us. And we'll do this very quickly because I'm told we are standing between the rest and tea.
Just do council members first.
Okay, I'm told council members first. Council members first, then the deans join next. Council members first. So next we have the deans. The deans present. Yes? Yes, we have the director. Chief Justice will request you to remain on stage, please, and Professor Dote, the UN doc representative as well. We request the guests from Uganda. Professor Munyoki can also join us. Dr. Munyoki, KLR, I call her professor. You say amen, you're going to be. Kenya law reforms, Madam Agimba. Zakim, ngoja na vidole kidogo. Kuna mkubwa anakuja. Kenya law reforms. Mungekuwa mnapiga makofi, nyinyi watu namna gani? I think that is enough. I'm ordered that that's the end of the photography session. Oh, I'm told the Legal Education Appeals Tribunal. Are you here? The tribunal? Quickly, before Professor Dote sits down, I need to have a job on Monday. CJ, my apologies. Mr. Zakim, we are good? It is so ordered. That's the end of the photography session. Thank you very much. We are going to have tea, and then we'll continue with the session. CLE Directorate, 20 minutes. 20 minutes, we'll have the tea downstairs. 20 minutes, we come back after that. Thank you very much, ladies and gentlemen. need to save on time.
His face at a non-camera.
The representative of the Solicitor General, is she here? The representative of the Solicitor General? I saw the Attorney General representative, Mr. Reddy. Is the SG's representative here? We welcome you to address us as we wait for the panel. The SG's representative. Allow me to also recognize the presence of the CEO Kenya Law Reports, Ms. Munyuoki. Karibu sana, asante sana. I also recognize the presence of the UN doc, UNODC, Mr. Francesco Cecchi. Thank you very much. They were to give us their remarks, but owing to time and protocol issues, please bear with us as we move on to the next panel. So the representative of the ASG, we will be waiting on you if it's possible. Yes, karibu. I'm told to wait a minute.
No, audio setting change.
Thank you very much. And soon after, we hand over to Mr. Ndong to take over the program. Mr. Wanyama, welcome. Thank you.
Okay, good morning. I'm really sorry about the protocol mix-ups, but I'm here. My name is Pauline Mcharo. I'm Deputy Solicitor General, and I'm here to give remarks on behalf of the Attorney General and the Solicitor General. I'm just not the Solicitor General's representative, but I'm the representative of the Office of the Attorney General and Department of Justice, representing both the Attorney General and Solicitor General. So, it's been an interesting 2 days, and it's been good. I've been learning a lot. I was here yesterday, and I'm here again today. But I will read out the remarks of the Solicitor General because he sent me to give his remarks. And his thoughts on this discussion that's been held today and tomorrow, and that was held yesterday. So I will read out his remarks. The chairperson, Council of Legal Education, the CEO for CLE, CEO National Council on Law Reporting. Of course, I have to recognize the chairperson, Kenya Law Reform Commission, my former mentor and senior, Madam Agimba. I'll also recognize Senior Counsel Charles Kanjama, and I'm also going to also recognize former President of LSK, Nelson Harvey, distinguished guests, colleagues, and partners, all protocols observed. Ladies and gentlemen, good morning. I'm deeply honored to join and address this distinguished gathering today. Ladies and gentlemen, legal education stands at the core of any functioning democracy, serving as a vital foundation for a nation's progress by cultivating the expertise essential for upholding the rule of law, granting access to justice, and driving national development. It achieves this by training ethical and competent professionals such as the judges, advocates, policymakers, paralegals, and in this discussion we've heard that the demand for legal training is very great in this country. The legal profession is undergoing a profound transformation. Technological disruption, the globalization of trade and services, the rise of digital economies, and the evolving expectation of citizens all demand a new kind of legal practitioner, one equipped not only with legal theory and knowledge, but with practical competencies, ethical grounding, and the agility to respond to rapid change. The traditional model of legal education, while foundational, is no longer sufficient on its own. We must now prepare practitioners who are adaptable, multidisciplinary, and capable of navigating complex, dynamic policy and regulatory environments. I'm pleased to inform all that the Office of the Attorney General has recently refurbished a full wing on the 8th floor, Sharia House building, to create a Sharia House training chambers, which will have training rooms with technology, and also an ICT hub for intense in-house and virtual trainings in emerging areas of law for the State Council of the Office of the Attorney General. We are looking forward to use the facility to have continual legal education within Sharia House and AG chambers, and also that will impact our regional offices. As you're all aware, the Office of the Attorney General is decentralizing to the 47 counties. We are now in 33 counties. So we'll use both the virtual and the in-house training platforms to keep on training our lawyers to be up to date. We are looking forward to also holding training sessions, hopefully with Strathmore University, on how ethical use of AI for research and to promote continuous learning within the Office of the Attorney General, to promote so that we can adapt and Council can adapt to the emerging areas of law. Competency-based legal education offers a path forward. It shifts the focus from what is demonstrably learned to the ability to apply legal knowledge in diverse real-world contexts. For Kenya, this shift aligns closely with our constitutional aspirations, the bottom-up transformation agenda, the Kenya Vision 2030, the ongoing justice sector reforms, the government's broader agenda of public service transformation, and the ambitious 2023 to 2027 CL strategic plan. Legal practitioners today are expected to advise on emerging issues such as cybersecurity, digital trade, and especially after the cyber hacks going on, it's a real conversation taking place all over. Artificial intelligence, climate governance, cross-border taxation, complex transactions, and as you can see within government, there's now the policy to adopt PPPs. So we are embarking on very advanced training for our council in AG's office on PPP for infrastructure. I know we are also embarking on emerging areas on debt management, especially to handle the issues of sovereign debt. So the complexities that are required in legal education are not what we traditionally learned when we were in law school. I know I ran, even as I give the remarks of the Solicitor General, I ran the capacity building arm of the AG's office. And our work is to try to keep up to speed with what's happening around the world. So there is really great need to work on emerging issues within the curriculums. This requires a deliberate cultivation of new competencies, including policy analysis, negotiation skills, quality of our regulatory designs, innovation literacy, and comparative legal reasoning. Ladies and gentlemen, we face challenges of uneven training quality, facilities that do not meet modern needs, outdated pedagogy, misalignment between academic training and market needs, This is reflected in the tensions between increased interest in offering law degrees and the urgent need to maintain rigorous quality and standards in legal education, and the outcry regarding the sheer number of advocates joining the profession without commensurate preparedness. And questions have arisen is where do we strike a balance in all this between quality and quantity? The solution to these challenges lies in a fundamental paradigm shift, the adoption of competency-based legal education framework. This calls for necessary legal reforms to align our training with global and sectoral needs. In fact, we have had conversations also with the university. As Professor Sihanya, I think I've had conversations with him on the pedagogy in the university not taking interest in public lawyering, government lawyering. The skills for a government lawyer are just not the traditional legal courses. You'd take comparison, Harvard University, the top global university, Columbia University, the Ivy Leagues, Oxford, all offer programs on government lawyering to prepare lawyers for the public sector. And I think the challenges we have within public sector is onboarding counsel on aspects of government lawyering. So that's something I would urge CLE, the universities, to look into and benchmark, particularly with the top global universities such as Harvard, how they train the government lawyering programs. The dialogue directly engages the constitutional and statutory responsibilities of the Office of the Attorney General and the State Department of Justice, Human Rights, and Constitutional Affairs. Under Article 156 of the Constitution and the Office of the Attorney General Act, Cap 6A, the Attorney General serves as the principal legal advisor to the government and provides strategic leadership in the formulation, coordination, and harmonization of legal policy in Kenya. This mandate necessarily extends to policy on legal education, professional standards, and regulatory coherence within the justice sector. As the office with oversight over the Council of Legal Education, we are responsible for ensuring that legal education institutions, including universities and the Kenya School of Law, meet the regulatory standards necessary to produce competent, ethical, and practice-ready legal professionals. This includes strengthening the relevance of the curriculum and ensuring that training is responsive to the needs of the industry, the justice sector, and the evolving nature of legal work both domestically and globally. Competency-based legal education therefore enables institutions to develop graduates whose skills match real-world expectations in advisory work, litigation, legislative drafting, and emerging practice areas. The Honorable Attorney General on 28 August 2024 constituted the Working Committee on Legal Education Sector Reforms to consider and harmonize the concerns and issues raised by stakeholders with respect to the legal education sector. The committee submitted its report to the Honorable Attorney General for consideration. One of the recommendations by the committee is the undertaking of statutory reforms through amendment, consolidation, and harmonization of the relevant statutes. Consultations on the proposed statutory reforms are underway. Ladies and gentlemen, we are no longer practicing law in isolated silos. The forces of globalization driven by technology, international trade, and the cross-border movement of people and capital have fundamentally transformed the legal landscape. International commercial contracts are governed by international principles. Disputes transcend borders, and our clients' interests stretch across multiple jurisdictions. The contemporary lawyer is by necessity a global lawyer. They must be equipped not just with deep expertise in domestic law, but with an international and global perspective, an understanding of comparative law, and an appreciation for the legal and cultural frameworks of other nations. The legal profession is viewed as a key service industry. Regional firms and multinational corporations operating in the ESC regime, ESC require seamless, integrated legal advice across borders. If Kenyan advocates cannot easily practice in other partner states like Dar es Salaam or Kampala, clients will simply turn to jurisdictions that offer that flexibility, leading to a loss of business for the legal sector. The goal is to shift from defending national borders to commanding the regional market. The East African Community Treaty and the Common Market Protocol mandate. They mandates the mutual recognition of academic and professional qualifications. And sadly, because I took part in the negotiation of the East African Common Market, between 2009 and 2010, we were negotiating the East African Common Market Treaty Protocol, and mutual recognition of academic and professional qualifications was a part of the treaty. 15 years later, this hasn't yet taken place, because the desire of the partner states was free movement of professional services, free movement of goods, free movement of investments, free movement of people. And there is critical need for stakeholders in the legal sector to accelerate the establishment of a full mutual recognition framework to ensure a unified legal space that serves the prosperity and integration of the entire region. And I'm very happy that the Ugandan lawyers are here, Tanzania. I don't know whether they're Tanzanian, but I've seen my brothers from Uganda here within the East African region. I was part of the high-level task force that negotiated this protocol over 15 years ago, and it's still not yet done, and I think it's time overdue. So some work has to take place to enable, to accelerate the harmonization and mutual recognition. Distinguished guests, the health of our legal sector is intrinsically linked to the quality of our legal education. We cannot simply teach the law. We must instill the values that make the practice of law a noble profession. There is need to integrate ethical and professional responsibility training not as a separate, isolated subject, but as a core thread running through every single course. Whether discussing contracts, torts, or constitutional law, the ethical dimension of decision-making must be highlighted. By investing in our legal education system, we are not just strengthening the legal sector, we are safeguarding the rule of law and reinforcing public trust in the administration of justice. Let us work together to ensure that the next generation of legal practitioners is not only brilliant, but profoundly professional and working with integrity. Finally, ladies and gentlemen, the future of legal education is a profound responsibility that demands a holistic and integrated response. It must be responsive to the economy, anchored in ethics to preserve public trust, globally competitive to address transnational challenges, and simultaneously locally relevant to serve the specific justice needs of our country. By embedding these pillars into the core structure of our legal institutions, we will ensure that the next generation of lawyers is not only technically brilliant, but also ethically resolute, technologically prepared, and ready to uphold the rule of law on every scale, from the neighborhood courthouse to the international arena. And the Office of the Attorney General will continue collaborating with the Council of Legal Education, Kenya School of Law, the universities, the development partners, and all justice sector actors to build a legal education and professional regulatory system that is coherent, future-oriented, and globally competitive. Thank you, and God bless you. Thank you.
Thank you so much. My name is Ndong Evans. I'm an advocate of the High Court of Kenya, and proverbially part of the last batch that was referred to as the 920 plus. So I think I consider myself to be in the right place to be able to hold this discussion. Allow me to ride on the protocol that was already set for the purposes of this conference. Allow me to welcome everybody from the academia, practitioners, the judiciary, and even those in the public service in the legal sector. Allow me also to recognize the presence of NTV and all the media stations that are here. Please welcome to this session. My panelists, I think they are now all here. Mr. Mwaura Kabata is joining us online. On the farthest end is Caroline Kasoa. Please welcome her. Followed by Mr. Peter Wanyama. And then next to him is Senior Counsel Kajama. And close, seated next to me is the famous General Nelson Harvey. Welcome all of them as we begin. Now, panelists and those that are at this conference, allow me to begin this conversation by saying that it is often said that the moment we stop talking, we start fighting. So I am grateful that we are not fighting and that we have come here to deliberate on these important issues on the future of legal education, especially the voices from the bar. Having practiced the law, I can see my panel is averagely 20 years of legal practice. I want us to start this discussion by posing the question, is there a philosophy of legal training that Kenya ascribes to? Do we have a philosophy underpinning our legal training? Do you feel we have a philosophy underpinning our legal training? And this is important because it will then answer the question whether we are training for employment, we are training for education, or are we training for leadership? I'll start with General.
I wish the Chief Justice was present to hear our rebuttal, but nonetheless, I believe the message will reach her. The starting point, Ndong, is this. Unless and until the educators of lawyers, the regulators, and those who admit advocates listen and see the propriety of us improving, then the future of the legal profession is doomed. And I say this informally because I've seen some measure of circumspection on the part of the lecturers, which is good. But the regulators and those who admit advocates are deliberate. In their premise, there is no problem. But you see, friends, Kenyans, it is imperative that we interrogate where the problem is. Because if we don't interrogate where the problem is, we'll not make progress. And this is the starting point. I believe my invitation to this conference was prompted by the tweet I made the other day. I quipped, we are admitting 920 advocates every month. So I was made to understand that's an average of 8,000 advocates. Is there a commensurate increase in the number of doctors, engineers, accountants, actuarial scientists? And nobody sought to interrogate that question. And what they did during the admission was to say that nothing will stand on our way by doing what is required of us to ensure that these 920 advocates join the profession. And therein lies the problem. And sorry, because some of us are paid and praised to speak the truth and not to pacify. The pacifiers have done their part. Ours is to tell you the hard truth. Because you as a parent, you as a student studying law, what is your expectation? When you're getting admitted, you're being admitted as an advocate of the High Court of Kenya. Let's not make any mistake about it. An advocate of the High Court of Kenya is just an advocate of the High Court of Kenya. He's a litigator. And then we will be told that there is need for us to diversify, improve the curriculum, so that we deal with emergent issues. That's a false construct. For some of us who are taught jurisprudence by Professor Kivuta Kibwana, we were taught that you cannot be made to understand the entire law. You can only be taught to know where to find the law speedily and how to apply it. Look, for instance, my classmate, Pauline, good to see you, has talked about the sovereign debt, money laundering, cybercrime, and PPP. Honestly, you can't teach these things in law school. It's an illusion. Because what you need are the basic requirements of a good lawyer for you to find out by yourself where the law, insofar as these germane issues are concerned, is found, and to apply it. And for as long as we do not have that culture in the training of lawyers, we'll not get it right. And let us make it clear, we are not averse to the increase in the number of advocates. We need as many advocates as possible. But we need to ask ourselves certain questions. If you go to the state of Israel, every able-bodied male and female of sound mind will know how to use a Jericho pistol, will know how to use an automatic Uzi rifle, will have basic training in all weapons, because that is what is required of them. So, do you want to make the law degree a basic entry requirement for every male and female adult Kenyan of sound mind? There is no problem. If you want it to be synonymous with a driving license, then so be it. But if our intention is to create entrepreneurship as the end goal of training an advocate, then we must interrogate the key issues. To that extent, therefore, Ndong, to close on this issue, the philosophy that informs the training of lawyers in Kenya is deficient. And those who are in charge of it have an imperative to listen. Otherwise, if you don't want to listen, we'll continue stagnating in this state, which is not conducive. There's no entrepreneurship in the end product of the trained lawyers.
Senior counsel.
Thank you, Ndong, for that question about philosophy. I'll just make a few comments. The first is I do recall that when the Council for Legal Education got involved in the process of getting law schools approved, they did request that every law school should have a specific area of focus. And of course, we know that there have been challenges between who approves law schools. Is it the Council for Legal Education or the Commission for University Education? But I liked that idea that law schools should not just be replicas of each other. Every law school should have something unique that the student who goes to the law school knows. If I go to a particular law school, this is their area of emphasis. They have maybe a certain philosophy, a certain expertise, a certain kind of like alignment in the way they teach law, so that parents and the students who are joining the law schools can have genuine choices. Right now, even though that is a theory, the practice is that every law school ultimately is about graduating as a lawyer. And this additional of what is that unique aspect of training that comes from one law school or the other, those of us in practice, we don't really feel. For me, I've been running a law firm for 19 years, and every year we admit pupils into our law firm. And I like to have diversity. So when I'm admitting the pupils, I like to pick from different universities, different gender, different regions, and so on. And I wouldn't say, with the experience of so many years, that there is a specific distinctive feature that I would say this is students of University of Nairobi, these are the law students of Moi University, etc. And that's why I feel that even though the ideal was that every law school will have some specific characteristic, even you could say philosophical leaning, the practice has ended up being that law schools exist to get students to graduate and enter the job market. Yesterday I was meeting some young lawyers, and as we were having a discussion with them, remembering how 920 lawyers were admitted, I asked one of them, when were you admitted? And this lawyer said 2 years ago, in an event where we were 800 lawyers being admitted. And I asked, based on your general knowledge about your colleagues, how many of them are in employment, either self-employment or they are working for another organization, and they're actually practicing law? And I was surprised when the answer was given was maybe about 20%. So what we are finding is that for the law school, the tendency has been to focus on pushing out the people with a degree so that they can enter the profession. And they come into the profession, but somehow the profession has not been able to accommodate all these numbers. So we are having that kind of like a lack of mismatch. We're having a mismatch between those who go to law school and some of the young lawyers, when they are in the law school, they are dreaming of becoming like their role models in the profession, like the senior lawyers that we all know and admire, including some of us here. And then when they come out, they start facing frustrations of realizing that getting a law degree, becoming admitted to the bar is not adequate for you to get where you want to get. But the last point I want to make, and this is with a bit of humor, is that even as we are suffering from this angst of so many lawyers, I remember when I was in law school in the late 90s, in first year, one of our lecturers came to class and spent quite a bit of time telling us that the class had become too big. We were now more than 100 students in the class. This was not how University of Nairobi used to be in the early 90s. And the lawyers are being trained, too many of them, and really put fear into us that the legal profession was not going to be able to embrace us or absorb us because we were too many. And then I was very surprised when a few months ago, I invited one of our senior lawyers, Chege Kirundi, and he was in law school in the 70s in University of Nairobi. And he was talking to some young lawyers because I'm a patron of a certain law club. And he told them, and I was really fascinated, that when he was in law school in the 1970s, his lecturers told him the same thing. The lawyers are becoming too many. And you know, so this they were being told in the 70s. I know they were told in the 80s. They have been told in the 90s because I listened in the 90s. I believe those who are law students in the 2000s have been told the same thing. So clearly, it has been like a concern about the increase in the number of lawyers that has been there from the 70s when there were very few. I feel that the real issue that the lecturers express as a concern that the lawyers are being too many is if we continue with the traditional structure of practice of the law, then of course the lawyers will not find a place to fit. You'll find this 80% who've been admitted and they can't get jobs. So we really have to scratch our heads and ask, how do we promote access to justice as we get more lawyers in the profession? We know that when you look at the global statistics of lawyers per capita, in Africa we have some of the lowest percentage of lawyers for the population. And we also know that even within Africa, Kenya is doing badly compared to, say, Nigeria or South Africa in terms of the number of lawyers per population. We are doing much worse. But if the lawyers are not getting jobs, then there's an issue. And we need to reflect on, is it a philosophical issue? Is it an issue of the need for the market to adapt itself, whether it is through alternative justice systems or other mechanisms to ensure that the lawyers who come into the market, they don't just look for the traditional pathways of advancing in the legal profession, getting employed in a law firm, but they look for new ways of having an impact, building relationships and rebuilding relationships. Thank you.
Mr. Pitanyo.
Yeah, thank you. I have never spoken while seated. Allow me to stand. With your permission, I can stand?
Yes.
Thank you. You asked a specific question. Is there a philosophy underpinning legal training in Kenya? From a practitioner standpoint, I have been in the legal sector now for 18 years, just under 18 years. And every year I endeavor to train at least 10 advocates, And what is the philosophy of training which I usually adopt? To package them for the market, I proceed on the premise that we have a problem on legal training in the country. We have a major problem on legal training. We are training lawyers who need to fit in a market which is exceedingly and increasingly competitive. It's a capitalist market. In this capitalist economy, somehow a lawyer must fit in. And the way the capitalist market works is that there must be something, for you to be distinctive, there must be something that you bring to the table. That is why I disagreed with my colleague Nelson Harvey on the issue about 2 weeks ago. I said there is potential for every law student who is trained as a lawyer, with the proviso, however, that they must possess the necessary skills, adequate knowledge to be able to fit into this highly challenging market. The market which shows you no mercy, the market which owes you no favors, of course, unless you are the daughter and son of the comprado bourgeoisie and all that. But majority of us are from the bottom. So how do you rise up through the legal profession? So there must be something that you bring to the table that is distinctive. And then this goes to then the quality of legal training that we have in our universities. What I can say is that there is generally a problem with the university training. Universities themselves have become a huge veneer, a surface refinement hiding so many problems, corruption, so many things, underpayment, university lecturers. So majority of them, you find they are not motivated to do proper legal training to the students who eventually graduate and come into the market. I've noticed that gap. Secondly, in terms of the character of legal training itself, I have noticed that there are certain basics which myself I use every day in the morning to fill that gap. There are certain basics that a lawyer must have, certain basics. And if they don't have these basics, they will not fit in this market. They will not be able to specialize. They will not go into a room and dominate a discussion to, of necessity, radiate the majesty of an advocate. What am I talking about? Communication skills. Yes. It looks like we need to rethink communication skills in our universities. How do you communicate? A speech, whether oral or written, is a sign of intellectual health. How do you communicate? You can quickly gauge a student who is going to be a good lawyer through their communication. How they communicate in writing. You give them a letter an assignment to write a letter to the client, then you can be able to see that there are gaps in legal training. There's some lawyers, law graduates who don't know how to communicate using basic English. Yes. The use of tenses. How to communicate using short and simple sentences, using connecting words. That is why that course at Kenya School of Law on legal training is extremely important and essential. So myself at the law firm, what I do is that I package my lawyers by ensuring that they're able to communicate. So every day I go back to my Form 2 lessons and teach them proper English on how to use parentheses, how to use connecting words, how to use active voice and not passive voice, how to avoid jargons and legalese, so that we're able to package them, so that when they are in a table or when they are drafting pleadings, there's something something distinctive that comes out from them. Because the market is looking for distinction. So we need to improve communication skills in our universities for our graduates so that they can fit in this highly competitive market. Improvement of communication skills will help the student to draft pleadings well. Nelson Harvey here doesn't tell you he's a good drafter, yes, because he's able to communicate well. If you have the basics of communication skills, you can then draft proper pleadings that are presentable, both at the High Court and Court of Appeal, And then judges will notice. You will create your own profile as an advocate. You will start dominating the minds of everyone. They will say, this person is distinctive. And slowly, when you move to specialize, you can fit in any economy. Because there are emerging areas of legal practice where we can fit all these lawyers, but they have to be properly packaged. Policy and legislative development in nearly all the sectors. As we grow our economy, remember the legal sector is so indispensable in the legal order, as we say, the legal profession. So as we grow our economy, then you will find that lawyers are needed in each and every sector, and for them in policy and legislative development.
Mr. Wanyama, so that we ventilate all the three other areas that are remaining,
yes.
What would be your summative understanding of the philosophy underpinning our legal training, and what would you propose so that we move to the next panelist and get to the two other issues?
Yeah, so my proposal is very simple. We need to rethink our curriculum at the university. Secondly, we need to also, our curriculum should be market-oriented. We need to identify the sectors of the economy which are growing and which need lawyers. I can give 2-3 examples. Technology and artificial intelligence. There are so many opportunities there. So many opportunities there for legal practitioners. How do we train lawyers to be able to fit in this sector? How do we train lawyers to fit in the field of intellectual property? I see Professor Zihanya is here. He can tell you there are so many opportunities in that particular field. So how do we improve our curriculum for us to train lawyers who are relevant in the market? And my starting point is ensure that you get lawyers through who can be able to communicate. They can speak and write well. So the philosophy of legal training as a starting point must of necessity focus on improving communication skills. Because once you are fully packaged, you can then be able to fit in whatever sector of the economy with ease. Of course, sometimes it takes time. You might also specialize by getting a master's degree. That is important. You can specialize by acquiring short course knowledge on short courses. Then increasingly, you will find yourself adapting from what I call analytical reasoning to a synthetic thinker. And that is what the market is looking for.
Thank you. I think, Caroline, even as you get to interact with that question, could you also make a comment on a discussion that has been lingering for a long time? There is the entire discussion of the disconnect between theory and practice. And this is the problem that I've had for a long time. How do we, for instance, brand those in the academy as theorists of the law who are disconnected from practice, yet they channel the very brains that we say are good practitioners? There is always that understanding that those in the academy are completely disconnected from the practical aspects of the law.
Thank you. You can hear me? Yes. Thank you for the question. Just drawing from where Wakili Peter has left and my colleagues, and then coming into your question, in my view, the legal profession definitely has a philosophy. The only challenge is, personally, I don't know what that philosophy is. Because if I knew, then we would all know it. And the first precursor to failure is not knowing where you are going. So the legal philosophy that is not known by either the student, the practitioner, or the judge, or the teacher, then tells us we need to develop a legal philosophy. And I'll just make it simple. Let us develop a legal philosophy that as lawyers, our job is social engineers for rule of law and human rights. I'll quote my friend Nelson Harvey, we call him Commander. He said in his remarks that you cannot teach every emerging area of law. What you need to teach someone is to think like a lawyer. When you think like a lawyer, then you are always unbundling what could be the human rights issues. Let me say, for example, you walk into a hospital today and you see people are waiting to be treated. It could be yourself. And after some time, you realize you went to hospital 10 years ago. You said, my foot is aching. After 5 years, you went and said, you know, actually my ear is aching. And then after 10 years, you discover that your whole fibula is completely deteriorated with osteoarthritis. But you then, when you start evaluating it as a lawyer, your finger was an indicator that you actually have some deficiency in your collagen or in your calcium. But somebody failed to pick it. So as a lawyer, what are you thinking? You don't need to think the way you need only to sue this person for medical negligence, but you need to think how to bring to account the entire medical system, which does not help a patient to discover the problem and address it. So for me, is to teach people to think like lawyers. That is the philosophy. The second question, which you have said, how do you relate the practical with the teachers or the theorists or the lecturers? For me, I'm come from this school because I also made a very a major comment on what Harvey stated. And my view was a bit different, and I said, for me, there can never be enough lawyers, just like there can never be enough sociologists or engineers, because as you continue with life, there's always a situation that needs to be resolved. But my problem of the disconnect between the theorist and the practice is, the old adage that you can never know me until you walk in my shoes is so true. If the theorist has never walked the floor of Mbagathi Hospital, has never walked the floor of Pumwani Hospital, or my hospital there at home in Mahonge, can you really think they can teach medical rights in a manner that is so basic that when somebody tells you, my insurance card is not working, you think it's empty talk? It is a reality. So for me, there needs to be a connection if we have to sustain. Thank you.
Thank you so much, Karen. I don't know whether we are able to have Maura so that he starts us in the next segment. Is he able to hear me?
I am.
Yes, Mr. Maura. There is a comment that Nelson Harvey did make here regarding who is a proper lawyer. He said that being admitted as an advocate means nothing else than a litigator. Now, in the broader discussion of how do we diversify in terms of practice, there is this discussion of who is the better lawyer, especially in this age of AI, technology, and everything. I have seen the data exchange between in-house counsel, practitioner, litigators, as Mr. Nelson Harvey puts it, those in the academy. If we are to globalize in a manner that ensures every advocate getting admitted gets their place into practice, so that we do not have this discussion of that we are having many lawyers into the market, how do we deal with this tension? Because there is the feeling that the better lawyer is the litigator. On other quarters, there is feeling that the better lawyer is the one who teaches at the university. The better lawyer is one in the corporate space. So how do you reconcile that kind of diversity? Maura?
Allow me first to tender my sincere apologies for not being able to join the panel physically. I am currently in Milimani. There is an advocate who has been arrested, and we are trying to see how to matter. With that, allow me also to write on the protocols that have already been established so that I save on time. There is usually this misconception that an advocate is a litigator at first, because we are admitted as advocates of the High Court, which is a colonial relic denoting the rank and the status of a High Court, being a court of record. But primarily what the practice of law is, it does not limit the minority who do not litigate. And with this, I am saying that practice of law is diverse. It can be in mainstream court practice, in litigation, in dispute resolution. It can also additionally be any other field that qualifies as practice of law, in-house practice, commercial practice, consultancy, and even in the academia. And specifically, most of the backroom conversations around the practice of law, to me, happen in the academia field, because that is where critical thinking, critical legal reasoning is nurtured and produced, so that there is no, it will be a splitting of the hairs if we attempt to say that the superior model on practice of law is done in courtrooms. That should not be our focal representation here. The practice of law happens at various levels across the playing ground, so long as you are qualified to practice law, and in fact, you indeed are a member of the Law Society of Kenya. The continuous assumption, which I think has no basis, that non-courtroom litigators are not properly functioning as practicing lawyers, is something that, in fact, I believe is a colonial relic, where the practice of law was not mainly seen as any other field except, attending court, addressing judicial officers, filing your pleadings, and arguing cases on behalf of your clients. As we are heading into a virtual system of legal practice, we are seeing the possibility of reduced number of engagement of physical representation of legal issues, both in court and outside court, because many other legal disputes are also resolved outside court. So to me, as a take home, every area of practicing of law is equally important and impactful, and not necessarily the mainstream practice of law in courtrooms. I hope I have been able to answer your question, Dong.
Thank you so much, Mr. Maura. Let me start with.
And congratulations for your admission.
Thank you. I am part of the proverbial 920, and that's why I'm here for this discussion. So, Mr. Harvey, two things. You have branded those that are not in active litigation as not proper practitioners, on one hand. On the other hand, we are having a discussion of, we have so many lawyers into the market, and when I was coming for this discussion, I did a small public participation in our lot of the people we were admitted, and I just asked how many of them wants to get into practice, and many of them told me, I want to go into IT, I want to go into tech. Some told me, once I get this degree, it's going to be a launching pad for me to do something and then get into public service. That's their desire. Others wants to go to the bench. How do we marry the idea that there is globalization and areas are widening as the number of lawyers are also increasing, with what Mr. Maura says is the colonial relic and tendency that an advocate must appear before the Court of Appeal or High Court and argue real and substance cases, as I have heard you say before?
Dong, I'm not in competition with anybody. Neither have I branded a certain specific area of practice of law as superior to another. I believe that misconception resides in the minds of those diminutive in their ability to appreciate what they have. All fields of the practice of law are equal. But you see, I have a constituency. I meet many parents and students who tell me, I want to be a lawyer just like you. I don't know whether I'm a good lawyer. It is not within my competence to give that testimony. On Saturday, I met my career master and history teacher, John Mark Wandera, and he told me, you're a good lawyer. And I'm not in the habit of contradicting my teachers. So verily, as day succeeds night, if you are using Nelson Harvey as a model of a good lawyer, then this is my yardstick. Neither am I branding anybody. Then when that is said and done, there is another false construct. It's a tenuous argument that emanates from the mouth of Maura Kabata. These are the people who will tell you, you can succeed in every field. But Kabata is in court. Who came to speak to you here? The Chief Justice of the Republic of Kenya, who is speaking to us from the Attorney General, my good classmate, Pauline Mucharo. In our midst is Sir Charles Kanjama, also my classmate, Lord Peter Wanyama, my good friend. These are distinguished court from lawyers. So you need to take care of your inadequacies. Some of us have no infancy in what we perceive to be right. And we make no apologies for that, because we love being hated by those with diminutive thoughts on their capacity. But that notwithstanding, every field must be appreciated. I appreciate Professor Sianya. I appreciate Dr. It's not, they're all professors now. I appreciate Professor Kameri Mbote. I appreciate Dr. Smokin Wanjala. These are my teachers. There is a particular competence that domiciles in them. You understand? There is a particular competence that domiciles in me. Look, I act for judges. I act for presidents. You understand? So if you, as a professor of law, must train lawyers to be good in whatever field they want to be, encourage them to pursue that pathway. There's nothing wrong. You understand? And in this field, there are sufficient twigs for everybody to patch. And if for whatever reason you have a bigger wingspan, like a kite or an eagle, then you will find an appropriate branch for you. But what is key and what must be emphasized, the training of lawyers must have as an end goal entrepreneurship. I meet lawyers and advocates who cannot even understand the factors of production. If you cannot understand the factors of production, and I believe Elisha Ngoya, you're here, which we were taught at class 6 and 7, then you have no business being a lawyer. Because at the tail end of this discourse, your wife, your daughter, and your son will tell you, Dad or Mom, I need money for shopping. So the accumulation of the knowledge, if it does not transcend to income, the end result of production, then it's useless. It is as simple as that.
Thank you so much. And Senior Counsel, even as you take up to continue with this conversation, Mr. Harvey brings up something interesting in the mix. The social engineering aspect that we train lawyers to be able to social engineer society against the commercial imperative. What Peter Wanyama keeps on saying, bread and butter. Where does that line lie?
Okay, so as I answer your question, I want to also contribute to the ongoing discussion. For me, my understanding is that lawyers play a very crucial role in society, and their role can be summarized as building and rebuilding relationships. Lawyers exist to make the human society healthy. In the Middle Ages, they considered 3 professions to be noble professions. I say that all professions are noble, and law and medicine deals with the human body, and the divinity studies deal with the human soul, and law deals with the human society or community. And this is basically a summary of the human experience. And law is very important because when we interact with other people, we are interacting based on relationships that we have with them. And we need to build those relationships. This is a role of the commercial lawyer. The commercial lawyer does not come in when there is a dispute. They come in to help people make agreements and hopefully avoid disputes in future. This is a very important part of the law. This is building relationships. And then when disputes arise, which is natural when people in society and are interacting with different expectations, you have the dispute resolution lawyer, the litigator, the ADR practitioners. And they come to rebuild the relationships. The job is sometimes to terminate the relationship in a way that is fair and just. Sometimes it's to ensure the relationship continues. So in the Nairobi Legal Awards, where I have been involved for a number of years, we came up with this idea that we must recognize and celebrate legal excellence among lawyers. We asked ourselves, in Kenya today, where are our lawyers practicing? Where can we find them? And so we came up with 3 awards for lawyers who practice as private practitioners or in law firms. One was for litigation practitioners, those who are involved in rebuilding relationships. The second was for commercial stroke conveyancing practitioners, those who build relationships. And we thought, as my colleague Nelson Javier said, President Emeritus, that you cannot be effective in the practice of law unless you also know about the business of law. We have some lawyers who are really good, but because they are not very effective in the business of law, eventually they are not able to earn money effectively. Their clients are not happy because the lawyer is chasing after fees and not able to provide the right service. So the third award is for a law firm manager or partner of the year. Basically, the person who is good in organizing managing a legal practice so that it can be sustainable and provide service effectively to lawyers. And then we recognize that lawyers are also involved in in-house legal practice. When Nelson and myself entered the legal profession, the percentage of lawyers in in-house legal practice was negligible. There were very few. We have seen over the last 20 years, in-house legal practice become a major thing, both public sector and private sector. I remember it was only around 2011 when the DPP decided to eliminate police prosecutors and ensure that all prosecutors are lawyers. So public sector, private sector, and even civil society. Before there were no lawyers in civil society, now it is a very big area. So we have those 3 awards for in-house legal professionals, lawyers, that is public sector, private sector, and civil society. And then we realize that the law has been changing. We have to recognize alternative dispute resolution, as the Chief Justice said, where 80 to 90% of the law is being dealt with. So we introduced a category for ADR practitioner. We recognize that very important legal practice is taking place in our academic institutions. So we have a category for law teacher of the year, because it is precisely those of you gathered here as law teachers who determine how the law is going to look like 10, 20 years down the line, who determine what philosophy those lawyers who come out into the market are going to have. Are they going to have a strong commitment to access to justice, to human rights, or will it just be a commercialized approach of making money? And finally, we thought that even those of us in the private practice, we are molding the next generation of lawyers by pupillage, and we need to recognize pupil masters. So what I'm trying to say is that the practice of law has been advancing tremendously, and it is up to us in the different areas where lawyers are practicing to give them what they need so that they can be able to embrace the challenges of the next generation. And ultimately, what we are meant to do is to help build and rebuild relations wherever we find ourselves, whether it is through using AI and ICT, other forms of technology, whether it is through globalization, whether it is in very local and basic cases like are handled in the small claims court. For majority of lawyers, of people in the country, justice is encountered in the small claims court or in these other basic areas, tribunals of rent tribunal and so on. And sometimes we may think in very highbrow language about how we will be climate change lawyers and so on. But we forget 90% of the lawyers have to be tooled up so that they can help people resolve their very basic crises or challenges, like the neighbor has moved the border boundary of the land and has encroached on their property. So I think both the highbrow and the basic aspects of building and rebuilding relations, that is the challenge for us lawyers.
Mr. Peter Wanyama, as you are making a comment, you've been really big on this issue of bread and butter. How do we navigate that with the social engineering challenges and taking it not just within the country but also in the East African region? We've seen what has been happening in Uganda, Tanzania, and even Kenya.
Allow me to just, as I answer that question, to react with on the first question. Who is a better lawyer? Is it the one who has a PhD and teaches at the university? Or is it the one who is in private practice and has been paid and has bought a huge Mercedes-Benz S-Class? Or is it the one who is in-house and working as legal manager? Myself, I believe that our market is greatly interconnected. And I believe in the philosophy of the famous economist, social thinker Adam Smith, that in whatever that you do what you do and do for and tread for the rest. Do your best and tread for the rest. Myself, Mr. Harvey says that I'm a litigation lawyer. Does he know that I'm actually a corporate lawyer? That while training as a young lawyer, I was introduced into capital markets, privatization, legal aspects of corporate finance, leveraged buyout transaction, futures, etc. But now getting into this market, and that is ties to the question, getting into this market where you're supposed to offer services, you discover that if you are a nobody, you cannot conceivably compete with established law firms when Equity Bank is buying Banguo Bank in Congo. They will go for the established legal practitioners. Is that correct? You cannot just set up a law firm and then no one knows you. Yeah. You can't conceivably compete with Anjaruan and Kana. They dominate the market, and that's how the system works. So for you then to rise up in the legal sector, there must be something that you bring to the table, something distinctive. That is why I said maybe it is easier in this capitalist economy to rise up the legal profession through public law. Because in public law, there are so many opportunities for legal practitioners, and the market can quickly notice you if you file a constitutional petition and you're able to argue it. So there's a perception that litigation lawyers are dominant, but that is a false perception. There are so many corporate lawyers outside there who are really successful. So it is important that we are able to then fit into this market as legal practitioners. There is opportunity for everyone in the legal market, even as the economy gets increasingly interconnected. Our economies are getting globalized. Legal knowledge is, for example, getting increasingly put in AI systems. Software that has AI embedded systems. As we grow our economy regionally, you will find lawyers who are needed in the regional market. Lawyers who are supposed to be experts of regional integration, you will find your relevance by institutions that seek persons who are supposed to advise them on issues arising from free movement of goods and services from one market to the other one. So there is opportunity for everyone in the legal sector. The tricks are as follows. One, you must acquire knowledge. You must acquire knowledge. Without knowledge acquisition, there is no way you can dominate in the sectors where you're supposed to specialize. So as knowledge acquisition is a sine qua non, an essential and part and parcel of a mind that wants to dominate the market. You must acquire knowledge. In 2007, I met a professor at Harvard. Later on, he died. In 2017, the late Professor Callistus Juma, he introduced me to science, technology, and innovation. How, and then he told me, how, as a lawyer, are you relevant in policy design in STI? Then I discovered a whole new knowledge that lawyers can give advice on STI issues and dominate the sector by simply doing a short course and understanding it, understanding how the policy dynamics in the sector works. You can acquire knowledge also through specialized exposure in an environment. For example, if you work at the Attorney General's office in the treaties department, you'll understand the whole regime of treaties. Then you'll acquire knowledge. In the long run, you will specialize and become an expert in that market. So there's no better lawyer than the others. All we need to do is to do what we do best in whatever sectors where we are.
Thank you so much. I think, Caroline, as you pick up, I'm trying to intertwine most of the issues because of the time we have, so that we get a few questions from the members in this conference. There is a third aspect that I would want you also to address as you respond to that before I give it back to Maura, then we get to the questions. There is the issue of ethics and legal training, which is quite a real issue right now, especially with what we've seen for the past 1 year. There is an emerging discussion of what is the place, for instance, of judicial temperament in our legal training.
Thank you for the question. It's heavy, ethics and temperament. I'll pick from where my colleagues have left on the issue of who is a better lawyer between a courtroom litigator and any other. My answer is all are practitioners in different spaces. But we cannot underestimate the importance of thinking on your feet. It is only the courtroom which will not allow you to use AI to respond to a technical issue that your colleague has challenged you, because there is no time. So you think on your feet. That trains your mind to think. Number two, in my view, litigation is a mathematical precision. It is not a social explanation. You must be able to know your target. You must be able to specify the course of action with precision. If you take a tired judge on a long fishing spree, you will lose the case and your client will suffer. And as all my colleagues have said, you'll get a reputation of losing cases. So for me, it doesn't matter whether you are in corporate, you have to get it right. But litigation trains you to be excellent. So for me, I would encourage colleagues here that in as much as if you're in corporate, get an opportunity to litigate. You will not lose, you will grow. So on the issue of ethics, the issue is this. You know, I don't know why we would like to think that you can use different parameters. You know, law is a culture, just like science, like everybody now on YouTube is talking about healthy living. Or drink this, don't drink this. Or fast this, fast. Because it's culture. So the ethics of law is the soul of practice. But I will want to differ with my capitalist colleagues they are lawyers, but they have also said it's business, PMO, Kanjama business, and commander. Because for me, capitalist makes you think about your client, not rule of law. And many times when I review cases, I work in the land sector. If you know me, I'm a land management practitioner, and I have developed expertise on that. And I look even at pleadings of major law firms. And sincerely, the Solicitor General is here. There is no way, as Wanyama said, if you have serious public lawyers, such of those cases would succeed. Because you are just defending, probably taking away public land. And because the lawyer who is representing in the matter has not been given facilitation, and the law firm, like Wanyama is coming with 5 lawyers, Kanjama 3 lawyers, Harvey is throwing jabs there, you are just one. I saw on the news my colleague Harvey really bringing out the state council, and I sympathize because I was young like her. If you know me, you cannot believe I used to be very shy when my first 2 years in practice in Eldoret. But I was injected. I had a matter with Ragot, and Ragot is a very serious litigator. So in my confusion, I've even come with open shoes to court, you know. And I'm thinking, and then I met Njoki Ndungu. And Judge Njoki in FIDA, she told us, first of all, you are a lawyer. It doesn't matter who you are meeting on the other side, but prepare and be confident and keep insisting to be heard.
Thank you.
Yeah, just allow me 1 minute.
Yes.
So as I'm talking about ethics, I'm talking that let us go back to ethics. And for the public sector, now that the AG is represented here and the CJ, invest in the legal departments. In the AGM, I raised my hand and I talked about defending the legal opinion. Fortunately, Mr. Kabata is here. Unfortunately, I thought the LSK president would call me and ask me, what do you mean defending the legal opinion? If we don't defend the legal opinion, there'll be no ethics in public practice. Because if I give an independent legal opinion and it is not taken in good stride, and the AG is not defending me to give that legal opinion, you cannot say you're practicing law. So the ethics is the root. It must be there for you. And you cannot tell me that you're focusing on capitalism if you are not looking at ethics. Because historical land injustices has come. Why are we having a lot of nullification of titles? Because lawyers focused on the client and not the rule of law. Thank you.
Thank you so much, Carol. Mr. Mwaura, if you're able to hear me, in just a few minutes, we want to take questions from the plenary. On this issue of ethics again, there is one aspect that I did raise and I'm not seeing it being ventilated, and that is the idea of, apart from just the ethics that goes into substance of matters, there is the courtroom ethics. Lately, we've seen extreme exchanges, almost close to blows, between judges, litigators, or even litigators themselves. Where are we in terms of our legal training and ethics?
The ethical standard that we live in today, and I hope you can hear me.
Yes, you can hear me. You can be heard, please.
The ethical value that we live in is not only affected in the profession, it is a national ethos that has not come alive to underscore and understand how we relate with each other. And I am happy that my very good friend Nelson Harvey is there with me, and Mr. Wanyama. The practice of law in itself has to be defined immediately with how we pick relations with those we offer services to. And it's not just about our relationship with the bench, it is about the relationship that as a legal service provider, you extend to those who consume your services, even clients. And so, if you look, and I am happy that UNODC is here today because I know we had a proposal to amend the curricula at the Kenya School of Law to include a key component of ethics on money laundering and countering of terrorism financing. We are getting more and more a practical reality that most of those who come out of the Kenya School of Law and join the bar do not seem to appreciate the traditional mentorship aspect of learning from physically seeing what is being done. That it is essential as an advocate to allow those who are senior in the profession to speak first. Traditionally, it is important that if you are in court, and I learned that because I was lucky enough not to get admitted when we were doing virtual courts, is that a senior member of the bar cannot be standing in court and you are seated. And ethics speaks more of the values that are inculcated in you from a younger age, and not what you learn in 1 year or 9 months at the Kenya School of Law. It is inherently you, so that you don't find yourself in a position where you almost are exchanging blows with a judicial officer in court or holding a firm position yet remaining respectful. And it is a very thin line. We need to see it from far. I have learned many skills from especially the panel that is before you today, because I had the better opportunity of engaging physically with those who came before me in the profession. And truth be told, we are different. We are all wired differently. We cannot ascribe to a set of ethical values without a guide. And that is why the Law Society has professional code of conduct and ethics, which if enforced, will form a level playing field for everyone.
Mr. Maura, I would request that you conclude maybe in 1 minute so that we take plenary questions.
Don't I have?
Oh, thank you.
I have.
Thank you, Mr. Maura. Now, we are going to take laser sharp questions from the plenary. I think let's keep it brief, because I would still want the panelists who have not ventilated on the ethics questions to do as they take the plenary question as we conclude. I don't know whether there's a microphone on the, or I can simply, okay, there's a microphone. Laser sharp, just keep it 30 seconds.
Good afternoon. My question is very quick, as we have this discussion, especially on the number of lawyers. We have, somebody pointed out correctly that we have a population of 55 million people. And I would think that the numbers are still low. Sorry, I'm not sure what's happening to the microphone. Isn't the question, the bigger question, that our too impoverished to sustain those numbers? Lawyers have a role to play in governance, which would improve lives of the general population, which would in turn answer the questions of bread and butter for lawyers, particularly the questions that Mr. Wanyama is talking about.
Thank you. I hope the panelists are getting the questions with clarity.
Thank you very much, Mr. Moderator. My name is Ivan Engoru from Uganda. I just have comments, and I will keep it brief, as you have directed. To Mr. Wanyama, I just wanted to support your submission and say that as senior lawyers, if we don't learn the etiquette of respecting and mentoring the young ones, we are sustaining a war front which we are not going to win because of the numbers. We are going to be an enclave, and we shall be throwing the ethics through the window. I have my own experiences which I would have shared, but because of time. Finally, Mr. Moderator, I don't know how the Law Society of Kenya is dealing with the issue of contempt of court arising from these direct confrontations which we have referred to. In Uganda, it's a live discussion in the various social media platforms. So sometimes that acts as the restraint. Otherwise, you would be seeing much more uglier scenes in our courtrooms. Thank you very much.
Thank you. At least from a lady also, so that it doesn't become a manel plenary.
Okay, I'm not a lady, but I think I have that right. I said my name is Moitui, the Dean School of Law, Kisii University. The first one is a comment that we cannot talk about an excellent lawyer. And if we do, then we would have excellent lawyers in different areas of the law. If it is litigation, if it is the corporate world, that way someone can excel in whichever field that they are specialized in. Now, the question I'm asking is about the question of etiquette and respect and discipline and all that put together. When we teach students at the School of Law, at the schools, then at the School of Law, they pass exams in those subjects of professional integrity and etc. Where does the rain beat them? Is it when they have joined practice?
Thank you. One lady, one last question from a lady, please. Keep it short.
Thank you very much. I just stood to make you feel happy because you've been looking for a lady. And anyway, my name is Koki Muli Grinyo. I'm the Dean of School of Law at Southeastern Kenya University. I just wanted to make a small comment. And that comment relates to the the debate on quality versus quantity of the graduates that we are producing at our schools. I would like to just say, in the morning we had the chairperson of CLE and the Chief Justice indicate that 90% of all the disputes that are resolved in our communities and the society are done so outside the judicial system, and only 10%. And the kind of curricula we have at our schools is geared towards producing graduates who end up at the bar, at the bench, and other areas that you have just mentioned before you started speaking. So I want to say that, in fact, the ratio of the advocates we should be producing, once we transform our curricula to include and take care of the dispute resolution mechanisms that are used by the 90%, will require even more advocates. I think the issue is to look at our curricula ourselves as law schools and incorporate the 90% not worry about the 10% that we are concerned at the moment.
Thank you so much. I think to the panelists, we have a very short time, just 1 minute or 1 minute 30 seconds each. The only limp I would add to this, even as you respond and make closing remarks, because we are coming to the end, is this. There has been a discussion that the ethics questions has been a top-down kind of application, in the sense that more weight has been on young advocates are not respectful to their seniors, when in fact many say that it should be both vertical and horizontal. What is the line between just being brave and being abrasive? President.
You know, I lead the most pivotal political party in the legal sector. It's called the Brave New Bar. So, two issues. The people who suffer no inadequacy insofar as the suitability, competence, accountability, and integrity is concerned, especially those on the bench, will have no problem with some of us who speak boldly on issues of accountability. You see, the Chief Justice was speaking here directly or indirectly about what we do on the social media. You know, if you were to ask a judge like Chacha Mwita, he will never be in our viewfinder on these issues. But the judges who suffer incompetence, who are predisposed to corruption, will do all that they can to ensure that they get gag orders against us from speaking. Same with the advocates. You see, I'm the only president of the Law Society who has ever been convicted of professional misconduct. To what end? Because we are calling for accountability on those who are corrupt, those who steal. And you see, we have no apologies for this. You understand? And to conclude, for me, for instance, Ndong, I've led advocates who are 20 years older than I in court. You understand? I've asked for the assistance of advocates who are much younger than I in court. So to quote what Professor Bernard Sianya said once, learning is like osmosis. It permeates both from the teacher and the student. And the moment you have this understanding, you'll never suffer inadequacies. One day, long time ago, about 18 years, I met Dr. Gibson Kamau Kure in court, carrying his books in a kiondo. You understand? He's lived his illustrious practice. He has attained a measure of satisfaction. He will speak to you, he will speak to the court. There is no problem. And this is the issue that I must emphasize in closing. Those who have defined and punctuated their tenure in practice, either on the bench or on the bar, will find a lot of discomfort when some of us speak. And they will categorize what we speak as lack of etiquette. You understand? As want of ethics. There is no want of ethics and etiquette in speaking the truth. understand?
Thank you, President.
And the moment you realize this as a lawyer, irrespective of where you are, then you must speak. Lawyers get killed for speaking the truth. Lawyers get jailed for speaking the truth. That is your work.
Thank you, Senior Counsel. And I'm requesting the panelists brevity as the excellent submissions you make daily on our screens.
Okay, thank you, Ndong. Since these are the last remarks, I will focus on the question of ethics. First, let me say that ethics goes beyond etiquette or dress and address, even though that's an important area of ethics. Ethics goes beyond a code of conduct. When I was in law school, we had a course on ethics, legal ethics. It was a 4th-year course. That was the first time we were encountering ethics in 4th year of law school. And it was mainly focused on the codes of conduct for lawyers. Since I have been the administrator of Strathmore Educational Trust for some years now, I can say that I really value the approach of Strathmore Law School, where ethics is something that is taught from first year. There are different courses on ethics in every year of the law school, because ethics cannot be something that is ingrained in you if it is just one unit that you learn in 4th year or 3rd year about code of conduct. It is something beyond that. It is about your attitude to justice, access to justice, human rights, and so on. There's an element of philosophy in ethics, but it goes beyond that one. So I'd like to say, in my conclusion, that there has been and there continues to be a dearth of ethics in the legal profession. And some of the reasons that result in that is a focus on maybe making money or consumerism. There are very many cases before the Advocates Complaints Commission and the LSK Disciplinary Tribunal, for example, of lawyers who have failed to account for client funds. And those kind of challenges, which are just some manifestations of lack of ethics. I truly believe that as we are in this conference discussing the future of legal training, one of the areas we must flag, where we all have to come together, practitioners, judiciary, legal academy, is to reflect on how to more effectively train and instill values, because ethics comes from values.
Thank you,
in the legal profession. To me, it is actually the biggest crisis facing the legal profession today is a dearth of ethics in the judiciary, in ourselves as practitioners, in the academy, and everywhere else where law is being practiced. Thank you.
Yeah, thank you.
Very short.
Yeah, very short. I'll keep it short. Myself, as a practitioner, allow me to say this, I have practiced law for 18 years without a single disciplinary case in the Advocates Disciplinary Commission or the LSK Tribunal. And on the question of ethics, I will make a recommendation that we need to introduce a component, or rather reinforce the existing training program and emphasize more on ethical legal practice. Ethical legal practice here, I'm talking about handling clients' money. There is a lot of temptations when you get clients' money. You see your colleague has bought a BMW, taken his friend to Dubai for a trip, and you are here just looking at clients' money. So we need to find a way of helping young members of the bar on how do you practice law ethically. It's a major issue. Every day you will find a lot of interactions between the police and members of the bar when it comes to handling clients' money. So ethical, you cannot practice law well if you don't emphasize on ethical legal practice. On the question of etiquette, and allow me to speak on etiquette in courts, you will be an experienced legal practitioner to know one thing. The forces, these subconscious forces, the predilections, the idiosyncrasies, the emotions, the issues that define judicial decision making. And then for you then to practice before a judge, for example, who has taken money from the other side to rule against you. How do you practice law before a judge who is openly corrupt? How do you practice law before a judge who who has made a decision already in your application and wants to jail your client. So the environment is very, very challenging, but it calls for you to be, as a litigator, in such an environment, you must be firm, but respectfully ensure that you maintain the concerns of the need to have an ethical bar, but be firm, because we practice law in an increasingly challenging environment. Just yesterday, I was handling a 1.4 billion shillings case. And there are undertones on corruption. Judges deny me stay. Yet on a matter where stay is almost automatic.
Thank you.
So what issues do you then adopt as a practitioner to practice law in this brave new world where you have to confront daily challenges of especially corruption? How do you practice law in our context? That we need to just find a way of having continuous conversations every day on how to adapt. Thank you.
Thank you so much, Mr. Wanyama. Caroline, maybe you take the shortest time possible so that we give our colleague, Mr. Mwaura, to conclude.
Can I say it discrimination? I'm the only lady. Give me at least double the time. I'm talking for many ladies.
No. We are pressed of time because of the program. We started a bit late, and this discussion might not be able to be fully ventilated. So the brevity, the better.
Thank you. On ethics, I would just like to agree with my colleagues, all of them who have spoken, and pick up from where PMO has left. That courage is an important ingredient. If you follow Warren Buffett, he talks about integrity and energy being key ingredients for any success. So ethics is at the soul, and you must be courageous. I think the law practice must teach courage, because without courage, you cannot advocate for your client. And if you don't have practice ethics, then you are always wanting to not to be seen. You know this thing of underhand dealings, because you don't want to be seen. So in my proposal on ethics is this. Let us introduce the LSK shadow JSC. Shadow disciplinary committee. If you have worked with the Federation of Women Lawyers or Human Rights, you know that shadow is an alternative way of showing what is wrong and having people moot on it, litigate on it, because that is the surest way to show that somebody is not doing the right thing. And if you have no capacity to be ethical, then you need to join another profession, not the law. And allow me to also call on women lawyers, that when you look at this panel, it has how many men? It has 4 men. We need to also come up and become leaders. And on this part, I'm calling upon all of us to engage the financial government industry. It is unethical for the CLE, for the judiciary, for AG, for LSK to pretend that a private practice can sustain lawyers. All of us know that we must provide an economy. And one of the biggest drivers, we have been told, of unethical conduct, even in elections, people want to be given cabbage to vote in a certain way. If you have financial independence, you will tell either Wanyama I'll vote for you or I'll not vote for you. You will tell Kanjama I'll vote or I'll not, or Harvey, and you'll not expect anything in return. So let us engage the financial industry of the government, both at devolved and central level. Going forward, the legal industry must be funded so that lawyers can be engaged by government just like doctors. Thank you.
Thank you. Mr. Mwaura, if you can hear me, maybe you can conclude for us in 1 minute.
Thank you so much. I will take a listen to that. I will speak about the number of advocates per capita in Kenya. The statistics still show we are still lagging behind on the internationally accepted standards, because that is about a citizenry population of about 55 million, over a registered advocate index of about 25,000, giving you about 2,000 plus per one advocate per citizenry. On the question about is something that Dr. Koki has introduced, which I think is something that should be made as a focal concentration in terms of the curricula that is offered at the Kenya School of Law and also at a university level, is that dispute resolution as part of the training of law forms a bigger chunk of how we are trained. And if a majority of that is evidently outside the ambit of the court, then a lot of focus must be made in reference to how training is done with a concern on the 90% of disputes that are resolved outside the judicial system. At the Law Society of Kenya, finally, we have the Ethics and Efficiency Task Force that we launched, which is an alternative of what Kasua is saying, where you report incidences that will ordinarily be reported to the statutory or constitutional framework of reporting abuse of court processes, including how judicial officers will be disciplined, and then the Law Society takes these complaints and acts on them with those relevant authorities. The less I say about having courage and how to engage with members of the judiciary when you feel that other issues are underplay, or rather they are undertones, the better for this conversation. Allow me not to speak about them.
Thank you so much, Mr. Maura, and we want to thank everybody, all the panelists. Feel appreciated. We were honored to have you to have this discussion that will shape legal trading. I can see my teacher, Mr. Ogade, is here.
Thank you very much. There's a photo that's going to be taken. The photographers, as the photographers are doing their thing, Mr. Sam Alosa, please join us on stage. Mr. Sam Alosa is council member for the CLE. Please join us on stage as we award the panelists with backpacks. Please come to the center when the photography is finished. Ms. Kasoa. Thank you. Thank you very much. As the photography and the award is happening, may I call the representative of the National Council for Law Reporting, NCLR, Mr. Ndong, and the panelists, please receive your gifts from Mr. Samalosa. Then we will soon thereafter move to the representative of the National Council for Law Reporting to tell us what they are doing, what do they have in offer for us. They are part of our sponsorship for this event. Thank you very much. Santi Sana. Thank you, the president of the BNB. I hope my membership is still intact, Rice. My membership is still intact, eh? Thank you. Santi Sana Sir Charles. Mr. Onyama, thank you very much. Caroline Kasoa, thank you very much. Thank you. Santi Sana.
legal practice, and also come up, generate products that speak to the emerging areas of law that we are seeing. And so what was spoken earlier on with relation to specialization of laws, we've also gone that direction because it is a need that has emerged that we need to meet. And so through various forums where we share what we are doing and we give an update of what is emerging, for sure, one of the areas that is very dear to our heart is that technology and legal capacities. So the connection of legal tech is very important, particularly for the work that we are doing. The area of law reporting, if I can single that one out, because we also have the other one where we conduct law revision, cannot do without technology. So the lawyers that you will find within the National Council for Law Reporting are quite specialized. That disability, is a major factor on how this public legal information is published is very, very critical. So legal tech becomes a very important area where we want to champion because, for instance, for us it takes 6 months to induct a lawyer to understand the law reporting skill. Yeah, 6 months. By the time they get into the cracks of actually undertaking a successful law reporting exercise, that is what has taken us in terms of the time period. So as a pupillage center, we endeavor to speak about this and bring them up to speed with what is required, the international standards, the local standards, the national standards. Now we are speaking about AI, very important, but we are also saying that go into the website and conduct your research there, because the kind of website we have right now is very facilitative. You can get those specialized areas there. The areas of law, we have been able to classify the laws according to the various areas of law. So it is meeting the minds and the needs that we get to hear about when we conduct satisfaction surveys. Yesterday, we started an inaugural public sensitization session with the judiciary, where we reached out to the judicial officers and the judges. We are looking at LSK next, so that then we can take them through the website and be able to understand how to navigate and do search in areas that they would like. We are also looking at the academia, which will be the next platform, and then go to the public, go to the various counties, parliament, and all these areas that have emerged as areas that we need to speak about. And so the innovation, very important, competence, compliance are very important for us. Even as we look at AI, we are happy that the judiciary is coming up with a policy guide for the justice sector. So very soon you'll be interacting with the website that has AI-enabled features, and they can satisfy you as you go along. But for us, whether nationally or regionally or even globally, we'd like lawyers that can work and can practice. From a law reporting perspective, within the region, we are adopting similar standards. So if you're a law reporter here and you go to Uganda, Tanzania, there's same principles. So the space is there. We have been challenged. The space is there. We can all fit there. But then it means that we need to identify our niche and the areas that we can occupy, because really the legal environment is dynamic. It is how we fit in there and finding that specialization that is important. Thank you so much, Prof.
Thank you. You can do better for Kenya Law Reports. Moja? Thank you. I have a special relationship with KLR. I've done a lot of my research through that platform. Thank you very much, KLR. I'm told there's a representative of Law Africa that needs to go for some national security issue. 2 minutes. Law Africa. Law Africa, Law Africa, we are waiting for you. 2 minutes. These are our sponsors. Without them, the tea, the lunch would not have been here. So accommodate us for the few minutes that we indulge our sponsors. Ama namna gani? Sio ni sawa? Let's clap for KLR better as we welcome Law Africa. Thank you.
Yes. Thank you, everyone. Thank you. Good afternoon.
Good afternoon.
I hope you're all well. I know everyone is hungry. I've been told 2 minutes, but it's very important. We wanted to bring you an update on a new tool that we're building at Law Africa. We've heard AI mentioned a lot today. How many of you are already using AI in your schools, in your firms? Not too many. A few? Okay. So we all know AI is changing how we do everything. And what I'm showing on the screen, you can press play. In partnership between Kala, which is a Kenyan AI company that creates digital public goods, and Law Africa, we are creating an AI deep research tool that you can use in your firms, for your students, in the judiciary, for your clerks. If you've ever tried to use AI to do your research of law with ChatGPT or Google Gemini, you'll see that it's often wrong. It's inaccurate because it's not trained in Kenya. So what we've done is we've taken all of the case law and reports and penal codes and all statutes all the way back to 1907 in Kenya and trained the AI on this data. And as new cases come out every week, they will be gazetted. As new reports come out every week, they will be loaded. So you can have an AI assistant that you can use to do your deep research and create research reports, to publish reports, to use within your firm, that is trained on accurate Kenyan law. So we're very excited about this. We will also be extending into other East African countries soon. And so we'll be launching in January. If you're interested in using the tool, I'm sure many of you are already using case law and ebooks from Law Africa. And so you will be able to add on this service as well. So instead of going individually one case law report at a time, one ebook at a time, you can access the AI Legal Research Assistant tool, and you can use it within your organization. So we'll be launching in January with a few people. If you're interested in trying it out as early access, we have a booth for Law Africa here. And so you can come talk to us. We'll take your email, and you can be on early access. It does a few other things like small claims assessment tools, legal templates, so pre-filling legal templates, Kenyan-focused legal templates, very easy. It gives citations of exactly where it's pulled the information, and it's accurate on Kenyan law. So we're very excited about this. Come talk to us if you're interested, and I will hand back the mic. Thank you very much.
Thank you very much. I am also told to acknowledge the Ethics and Anti-Corruption Commission, who have helped us with the media coverage for the last 2 days. A hand of applause to EACC, please. We will be repeating that after lunch. That's not how to clap. Anyway, a couple of in-house announcements. I'm told that some of us were given lunch vouchers. How many received the lunch vouchers? You will be showing them to the ladies down there so that you don't get a second one. Those who have not received, please get one from the ladies who gave you the vouchers yesterday, as we go for lunch. That is accountability, so that we help the Secretariat deal with the maths. Please, if you have one, don't take. If you don't have, get a new one. Did I forget anything? That is okay? Ladies and gentlemen, thank you very much. Bon appetit. See you in exactly 1 hour. We start here at 2 o'clock. Thank you very much. The sessions for the afternoon,
30 minutes.
I'm told it's 30 minutes.
So we start at 2:30.
We start at 2:30. So 2:30. So the sessions will be here. It will be a combined session moderated by Professor Omara and Dr. Ambassador Koki Grignon in this same place. Thank you very much.
habit of, they love hearing their voices. And I have been tasked with co-chairing these combined sessions. The breakout 1 and 2 will happen here. And we had agreed that the first session will take 30 to 45 minutes at most. And then the second session will be 30 to 45 minutes at most as well. And therefore then, I want to ask that we take this opportunity to welcome Dr. Lail Latif from the University of Nairobi. Then we have Dr. Ivan Ngoro from Makerere University. Ivan, just wave. And then we have Dr. Cecilia Ngaiza kutoka Tanzania. Tafadhali na tupungie tu. And then finally we have Mr. David Sigano from the CEO EALS. And the Daktari has the privilege of understanding what happens in the region. So we want to have him speak last. What we are focusing on today is regional perspectives on legal training, AML, lessons from Kenya and EAC. And we are glad that we have representation from Uganda, we have representation from Tanzania, Kenya, and then EAC itself. So I want to ask that we, and we had agreed that we are doing the 5 to 7 minutes on your remarks, and then we'll follow up with any questions. You feel free to make your presentations there or here, and time yourself. I don't want to say, okay. Other than that, let me have the privilege of inviting Ivan. Let us all do the Ogada claps, even as we welcome Ivan. 1, 2, 3. Ivan kuja. 4. Open. Closed. Ivan, please.
Thank you very much, John. Good afternoon, our dear participants. My name has already been mentioned to you. First, allow me to thank the hosts, Professor Muimali, for extending the invitation to Makerere University. John has given me a hard task to start off. I hope speaking to you about our experiences as a country, but partly it also stems from my personal experience as a teacher of law for the last 16 years. I will start with the positives and then end with some challenges arising from some policy change. So first, participants, allow me to say that I think it would be fair to thank the government of Uganda for the change in policy in access to university education. This came about as a result of liberalization, which gave an opportunity to entrepreneurs who wish to take a shot at university education to provide some kind of complementary support to existing institutions. So that's a plus. But the negative which came with that is that we had a big number of students enrolling at different universities. Makerere was not spared at all. So from a class that used to be approximately 80, we now are dealing with a class of about 280 to 300 annually. So that has given rise to its own challenges, and I'll go through them briefly. Increasingly, I don't know what the situation is in Tanzania, which I'll hear. We are having a big number of absentee students who attend through proxies, next of kins. So if you're speaking about maintaining standards, that certainly is one of the reasons that could be contributing to low standards. And most of these students who attend through the next of kins are also very powerful they have lots of money, so enforcement of the code sometimes can be problematic. Relatedly, the teacher-student ratio. The National Council for Higher Education has standards with respect to teacher-student ratio. I think it's 1 to 50, but that is also a challenge of its own because it has an issue to do with the wage bill capacity of a university to be able to recruit a commensurate number of university staff to deal with or to meet that requirement. In terms of entry point, as a country we are dealing with 3 entry points. We have direct entrance from senior 6. We have another category who possess ordinary diplomas. And then we have a third category who most likely could have done training in other disciplines, sitting what we call the mature exam. But the leveling requirement is that we pioneered what we call the university pre-entry examinations for purposes of our Bachelor of Laws. And dear participants, this speaks to the issue which was raised Lumumba, that back in the day, it was an issue of, book smart, AA throughout. So the requirement to qualify, again, down from what we were all used to of, double A and maybe double B, and then your is what we got. A little young lady.
And I'm glad he said that the leading girls' school in Kenya would be Alliance. If he had said leading boys' school, we would have had a discussion. But with that, then, let me take this privilege to welcome Cecilia. Thank you. Welcome. And let's appreciate Cecilia, please. Karibu sana na utuhamasishe. Hapa hatuogopi kuhamasishwa.
Hakika, asante sana. First of all, I would like to start by thanking the organizers for the invitation. For invitation extended to the University of Dar es Salaam School of Law. We all know that's where the journey of legal training in the region began, so we really appreciate that. I'm here standing before you on behalf of the Dean of the University of Dar es Salaam School of Law, who could not make it today, and I represent him as the coordinator of undergraduate studies at the University of Dar es Salaam School of Law. Well, I was assigned to say something about the comparative aspects from Tanzania and Uganda on legal training, accreditation, and anti-money laundering curriculum integration. Actually, this made me think beyond what we do at the School of Law. For the first time, it made me think beyond the normal practice that we conduct with the students and ourselves as colleagues. And in doing so, I used Uganda as the main case study of comparison and found out that we do have a lot of similarities, actually, from how we train our students. The first discovery was that we both use two-tier system, which involves 2 stages. First of all, the first stage is an academic stage, where we train our students to acquire their LLB degrees for 3 to 4 years. I don't know about Uganda, but in Tanzania we do have universities which are offering their LLB degrees for 3 years, and others that are offering their LLB degrees for 4 years, including the University of Dar es Salaam. And we do have universities like the University of Mzumbe that offers their LLB program in the span of 3 years. And here the difference becomes more visible when these students meet at the law school. There has been some, I don't know, what can I say, in Tanzania tunasema story ambazo hazijahakikishwa kwamba most students from the universities that take their LLB degrees in 4 years tend to do well in law school compared to those who take their LLB degrees in the span of 3 years, but I have not been able to research on that to come up with specific answers on that, but that has been the experience of most students at the Law School of Tanzania. It is a repeated story, yeah? So, yeah, the two-tier system engages, as I've mentioned, the academic stage where we train students for LLB, and the universities which offer this kind of degree are regulated by the Tanzania Commission for Universities, which is an equivalent of the Uganda National Council for Higher Education, right? That's what we also do. I found some sort of a similarity there. Also, after the students have graduated from the LLB, those who are interested to become advocates proceed to the practical training at the Law School of Tanzania, which for Uganda, there is an equivalent of that, which is the Law Development Council? Center, okay, Law Development Center. So I could spot some similarities between the two countries, but I'm not sure whether you talked about the entry qualifications for the LLB students. In Tanzania, I'll give an example from our school, that we do have direct entry qualifications for our students who are joining the LLB program, and we also do have equivalent qualification, whereby under the direct entry qualifications, we admit students direct from the secondary education with advanced certificate of secondary education. This in acronym we call ACSEE, while those who have taken the alternative route of doing certificate in law at our school or diploma in law at the institution of judicial administration may also be admitted, but in a very lower number. At the University of Dar es Salaam School of Law, we offer certificate in law, and at very minor opportunities, we get to admit students directly from the certificate program to the LLB program. Only those students with a distinction mark would be admitted to the law degree. Yes, apart from the certificate in law that we offer at the University of Dar es Salaam, you will hear me citing examples mostly from our school, because that's where I have worked the longest. We do offer Bachelor of Laws, LLB, from, of course, 1961. And when the year 2009 came in, we were successfully able to launch another program known as the Bachelor of Arts in Law Enforcement. And the primary objective of this program was to train law enforcers in practice, particularly the police officers, to the degree, to the level of degree. So this group was the primary target, but currently we also admit freshers from secondary schools who are aspiring to become law enforcers to join the Bachelor of Arts in Law Enforcement, which is actually a unique program, I can say, and a sole specialized degree on law enforcement across universities in Tanzania. Yeah, so I will quickly jump into the integrating anti-money laundering curriculum in the legal training, and I will, of course, cite examples from our school again. So I I had to mention about the Bachelor of Arts in Law Enforcement because it's also part of the legal training that we do. Of course, we train this course with other trainers who are not lawyers. Some of the trainers are from the Immigration Department. Some of them are from the Prevention of Corruption Bureau. Some of them are from the police force. And this program is very potential to accommodate the anti-money laundering modules. So far, we do have courses under this program which do accommodate anti-money laundering curriculum, which are, of course, we have many courses taught under this program, such as law enforcement institutions, psychosocial studies, criminal investigation, and etc. But for those specific programs that accommodate anti-money laundering modules are the financial crimes, a course on financial crimes, which is taught in the second year of the Bachelor of Arts in Law Enforcement program. We have a course known as cyber crimes, also taught in the second year of the program. We also have a course known as transactional crimes and the law enforcement intelligence and application. All these courses do have modules reflecting the roots of anti-money laundering practices. As to the LLB and the certificate in law programs, of course, we have reminded ourselves times and times again to ensure that despite the fact that we do not have anti-money laundering modules in most of the LLB and certificate in law programs, but at least we should always accommodate emerging issues, or sometimes we call them contemporary issues or cross-cutting issues. So in courses like criminal law and public order under the certificate in law program, they do teach some modules on anti-money laundering. Yeah, also under the Bachelor of Laws program in courses such as criminal law and procedure, banking law, which is an elective course for the second and third year LLB students. Also the course of international trade and finance, the course on tax law 1 and 2. We do incorporate elements or modules on anti-money laundering as contemporary issue, but we do not have a specific course on anti-money laundering under the certificate in law program and Bachelor of Laws program in the LLB and certificate in law programs. I think my time must be over.
And yes, and you've done a very good job.
I will end here. Thank you so much.
Tafadhali, let us appreciate with Obama claps. Let's just do Obama claps. Let's just rain claps. Let's just rain claps. Asante sana. Thank you very much. And I'll ask you a question. For example, and you'll answer this as a follow-up. We had the privilege of hearing from and then there's always a numbers issue. Does Tanzania have challenges with numbers? But it's a question that you'll answer after this. I can confirm that Dr. Laila was in school. She was my classmate at the University of Nairobi. And Daktari, karibu sana. Welcome. You choose to start. Yeah, please. We agreed. She's brilliant, so she will keep the time.
I hope so.
Please.
Thank you. Thank you very much. Hello, everyone. My name is Leila. So pardon me, I have a really bad throat today. Thank you, Professor Wamwara. Thank you, Professor Mwiwali, for inviting me to have this conversation. I think the topic is really important, anti-money laundering and how it is embedded as part of legal training in Kenya. When you talk about money laundering, it's not just a national issue, it's an international concern. So what we've noticed is that when you think about the Financial Actions Task Force recommendations, you'll have a bunch of global north countries seated in a room that are going to now make the decision on what they feel are the important laws and the important institutions that have to be implemented and embedded in all countries around the world to prevent them from being part of the blacklist or the grey list, which is the one that says that the country has a lot of secrecy, it's not accountable, and it allows for money laundering to take place. So what we found at the University of Nairobi, and that's where I work, so I'm going to speak about what we do in terms of anti-money laundering as part of our integrated curriculum. So we noticed that when the FATF recommendations are being made, or recommendations are being made at the OECD level as part of the 15 action points on base erosion and profit shifting, most of these conversations have a very Eurocentric perspective. There's nothing African about it. And when it comes to Africa, our legal systems are very different, and so are our institutions from the global north. Basically the European and the US institutions. So we kind of felt that it's really important to decolonize this field, and in decolonizing this field we have to work within the dimensions of where the world is moving to. So where are the conversations of money laundering happening? They're happening in the field of illicit financial flows, and they're also happening in the field of base erosion and profit shifting. So it's an entire part of the fiscal policy. So what we did at the University of Nairobi, this was in 2016, we set up a committee on fiscal studies. And as part of this committee, we have 4 streams that we try and work together with a bunch of our colleagues at the university on how we can bring in the political economy around illicit financial flows, base erosion, which is the broader angle of money laundering, into research, into our teaching, into our trainings, and how we also collaborate with specific partnerships. And we think this model really works very well. So in terms of research, for example, we are heavily involved in conversations with the United Nations, particularly on the Framework Convention on International Tax Cooperation, because part of the articles in this tax design that we're going to have at the international level is to understand how to combat illicit financial flows. And money laundering is part of this conversation. So through the committee, we're already producing a lot of policy briefs and research papers that are going to the UN to inform them on what should be the African lens when it comes to now combating money laundering going forward. We also send submissions to the OECD as part of the base erosion profit shifting project under either Pillar 1 or Action 5, which is on removal of harmful tax incentives, and also issues to do with special economic zones, and on the most important concern, which is transfer pricing, because we find that it is these areas that are now abused for purposes of moving money through layering, integration, and then of course facilitating into different countries. So just like Dr. Ivan has said, and my dear colleague from Tanzania, stand-alone course on AML on its own, because it can't be ring-fenced to the conversation around money laundering itself. It permeates everything. It permeates the tax systems, it permeates the legal system. So you've commercial law and securities regulations at the LLB level. So part of these 4 courses that we have, we're now trying to embed the understanding of what is money laundering, happens at the capital markets that could be an indicator for example, a Russian conglomerate is trying to use the Nairobi International Financial Center to examples about this is what has happened and this is what we need to do in terms of embedding stronger laws, not just implementing the FATF recommendations, because these are just policy recommendations in how we've embedded this conversation around anti-money laundering. And then we also have technical trainings. So we believe legal training cannot just be within the 4 walls of the university. Yes, we've got to train our students, but we also have to train the legislative draft persons. We also have to train the interpreters of law themselves, and also the makers of law. So we work with Kenya Revenue Authority, and we also work with the Tax Appeals Tribunal, and we offer them short workshops for either a day or 2 to be able to explain, for example, if this is transfer pricing, multinational corporations are applying arm's length principle, but then if this multinational corporation is embedded in the Cayman Islands, and if the shareholder is a person whose beneficial ownership cannot be traced, then most likely there has been some sort of an abuse within the transfer pricing regime. So we try and unpack that so they're able to understand how corporate legal vehicles are also being utilized for purposes of moving around money that is dirty money actually. So we work with these 2 institutions to try and empower them so that they're also quite good and they're quite robust when it comes to also investigating and thinking through the cases that they have where some of these issues may be occurring. We do also have short courses whereby we do train the public. So by the public, I'd mean any person who has a stakeholder interest in these conversations around money laundering. But we don't call it money laundering. We refer to it as illicit financial flows. Because once you understand the broader ecosystem within which illicit financial flow works, then you're able to spot exactly how money laundering is occurring. And I think with the way in which the digital economy is moving, we've got the dark web, and there's a lot of unregulated movement of cash that's taking place there. And how does money laundering also become part and parcel of this dark web? So we've got courses on that trains not just our students, but the general members of public who are interested in the same. That's our technical trainings that we do. And then we also have partnerships. And I think the partnerships are very important because we work with partners. For example, the Africa Capacity Building Foundation, it's a body within the AU. They have the mandate to be able to create courses that are available online for free and that they are certified. They're available to everybody. And they've specifically focused on Africa Union member states, so policymakers. And the conversation was that people need to understand at the policy level, at the legal level, and also at the public level that money laundering is taking place, and it's taking place in such an invisible manner that it could be right in front of you and you can't really notice that it's happening. So think about certain car showrooms, right? The second-hand business car dealers. That is a hotspot for a lot of money laundering that is taking place. But then what do we do in terms of strengthening our laws? So we've designed courses with the ACBF. They're called Good Governance and Transparency in Taxation. That's the first course. The second course is called Taxing the Digital Economy. And as part of these two courses, we've embedded the conversation around money laundering, how to identify it, what are the new faces of money laundering that are creeping up as a result of the digital economy, and also artificial intelligence. And then how do we go ahead and combat it going forward? So that's the partnership model that we have, and then we have so that's with the policy level engagement. But we also engage with civic society. So there's the Tax Justice Network Africa. We've collaborated with them as part of Committee on Fiscal Studies at the University of Nairobi. And with TGNA, we now also train civil society, NGOs, journalists, and media houses on spotting these issues that they occur, and how to go ahead and combat it. So I'll stop here for now. Thank you.
Thank you very much. Let us appreciate. No. Can we do it better? Let's appreciate it. Let it rain. Let it rain, clubs. And even as you spoke, it came to me. We don't have a standalone course on anti-money laundering. Would it be just think about it would it be counterproductive to have a standalone course? I also know that there are universities that have white-collar crimes as a course that stands out, and how would that compare? And then finally, ESC as a sub-regional or a regional legal player, but also I know there are also other ESC countries that are not being represented here. If you have any interest or any thoughts about them, please. And then David Sigano has this distinct privilege of having gone to the best school in this country, and I happen to have gone there as well. So David, please. School means high school, not. Thank you. Okay. Ask us which school, but David, welcome.
Thank you, Professor. I confirm that me and Professor went to the same school. We call it the school. You've had the confirmation that we do not have a specific course in any of our universities. In fact, the top 3 universities that provide law courses in East Africa are in Frontier: Makerere University, University of Jerusalem, and the University of Nairobi are here, and they have all confirmed that there is no standalone course. I don't know about other universities represented in the room. I know right now we have so many law schools providing really good courses, but this calls our attention to the fact that we do not have a specific course. And this has been something that has been on our minds. In fact, me and Dr. Latif have been working together a lot providing the training that she's been talking about, the training that you get after you leave law school or you get admitted as an advocate. And we do that under what we call the ELS Institute. The ELS Institute was created to provide the continuous professional development for lawyers in East Africa so that we cover any gap that we see in law practice in East Africa. I also have to say there are several differences between the courses that are provided for lawyers across East Africa. Tanzania, in Uganda, in Rwanda it's called ILPD. In Burundi it's not there. In Zanzibar it's not there. So there are those differences that emerge when it comes to law training in East Africa in terms of how is it undertaken. And we've been working with the Inter-University Council to have this harmonized. And we have faced a lot of challenges, to be honest. Because if you start with a country that has two systems, where there's 3 or 4 year, already there's resistance within that country. So when you go out and try to harmonize it across the region, it becomes even tougher. But then there's need that the university education, especially legal training, be harmonized. So that by the time we get someone admitted to practice law in East Africa, we know they went through an almost similar course. And so we believe there will be more competency, there will be more acceptance, and this is very important when it comes to cross-border engagements. Because then you have that trust and belief that the training that someone in South Sudan received is more or less the training that I received in Kenya. So when I'm engaging them, if I am their client or I'm hiring them for legal service, there's that trust that this particular person has more or less the same competencies. And this has been one of the problems facing what we call cross-border practice in East Africa, because our training is not similar. So there is fear among partner states that do we allow individuals from that particular state, for instance, if someone was admitted as an advocate without having to go through the law school or the law development center. There are countries that actually do admit within East Africa people without passing them through the Kenya School of Law or the Tanzania School of Law. You mean you leave law school, you do a little bit of practice, and you are admitted. In Tanzania, for instance, you can actually be admitted. I don't know that you don't need to be a lawyer. Without going into the law school, you can still be admitted, especially if you serve for more than 10 years. You can still get admission as an advocate. So there are a lot of variances. Of course, the East Africa Law Society is working a lot towards realizing it, but there are several hindrances, including training. I wanted to address something else. When it comes to anti-money, it's a very cross-border kind of offense. And from what I've heard from our dons here, we do have this training, but it's very restricted in one way or the other to the national level. So you could have it in a course on banking at the Makerere University, but it's limited in a way. And in my research for this session, I found that most of our training doesn't go deep and review. I know we review our curriculums quite regularly. We embed it more deeply, and maybe we can have the recommendation by Professor Wamwara that we have that is focusing on this. And while doing that, we should also think deeply about having an ESC course for...
Okay, we will probably need to sit down and really reflect on should we have a standalone course, and maybe we can have that at the postgraduate level for maybe 1 to 2 years, but then at the risk of duplication, because majority of these issues around money laundering and anti-money laundering recommendations that are there can be handled as a specific module within an entire course. So you can handle it within international taxation, within public finance, within professional ethics, within commercial law. I think all lecturers, professors should be sitting down together to say that if your topic touches on money, on finance, or cross-border movement, then you need to have an element of money laundering and anti-money laundering as part of your curriculum design in itself. So at the undergraduate level, we can embed it across board, but then at the postgraduate level, we really need to think whether it would make sense to have a standalone one, because then I don't know where do you draw the parameters of it, because international taxation is so long as well, right? So just that. Thanks.
Thank you. And guys, do you suffer the challenges of numbers? And then as you answer that in one paragraph as well, Doc, I want to ask, the pre-entry, is it anchored in law, and is it a common practice throughout Uganda? Yes or no? And then let's do that, and then please. Yes. The numbers. Do you have challenges?
Thank you. I'll talk about the numbers in terms of admission of students into the University of Dar es Salaam School of Law and the Law School of Tanzania. In relation to the University of Dar es Salaam School of Law, we do admit a total number of 160 LLB students each year, and only 45 students for the Bachelor of Arts in Law Enforcement, and this is due to our capacity to train these students and our struggle to ensure quality of education that we offer. And at the Law School of Tanzania, we do admit, I'm sorry, I'm saying we do as if I work there, but anyway, that's a practice. At least 600 students in one cohort, and we do admit 2 cohorts annually. And there is still a challenge of demand in the community generally. Per the 2022 census of national census, Tanzania mainland alone had about 60 million people, and the total number of advocates that we do have who have been admitted since the beginning of time so far in Tanzania is only 13,446. And in this total number, some are practicing advocates, which are only 9,553. We do have non-practicing advocates who are 2,244. We also have our colleagues who have passed away, like the total would go up to 750. So the ratio between the number of advocates we have and the demand is still
very low.
It's still very low.
Thank you very much. And finally, I don't want the challenge of we are not, no. Just one last question I'd ask him. Let me just answer. Oh, wow. One word, then we go.
Thank you very much, John. I will also use this as my parting shot.
Yes. Do we have a law?
The National Council for Higher Education and the Law Council are our regulators. But the pre-entry is anchored in the fact that in the law, which recognizes that universities have autonomy.
Autonomy, okay.
Yeah, that is the basis upon. They determine who gets into their house. So that is the basis of the pre-entry.
Very well.
And John, just in 30 seconds, most of the other law schools have since adopted that approach in admitting students to the LLB.
Very well. Thank you very much. Let us appreciate the whole of us with Ogada claps. Let's do 3 Ogada claps. 1, 2, 3. Funga. Fungua. Asanteni sana, Daktari and Your Excellency. Please, welcome. And the next panelist, please come. Dr. Low and many others. Unless... Okay.
Thank you. Good afternoon. Please, may I have Mr. Barak Oganda, Dr. J. Murungi, Professor Dr. Moni Wekesa, Dr. Lynette Osiemo, Dr. Judith Olo. Please take your seats at the front, otherwise we might be speaking to ourselves. As you can see, the hall is getting, how do you say? Emptier and emptier. That's a word. Karibuni. Another chair is going to be actually put. If you don't mind, I would like to sit there eventually. Please help us with an extra chair. I think I have all my presenters. One, just this big, wonderful chair. Yeah? Oh, okay. It has to look the same. I don't even think there will be time for the project. Okay. This one also. Okay. Good afternoon, good evening. My name is Kokimuli Grigno. I'm stepping in the shoes of Professor Mwimali, our CEO of CLE, and I appreciate this opportunity. I want to observe all the protocols from the morning. This afternoon, we are going to look at the emerging areas of legal education, and we have our speakers ready. And because we have so little time and we need to hear from them, and they are prepared very well, I know I will be in trouble, but I'm going to, Dr. Murunji, I'm going to request that we spend 10 minutes, and so highlighting the key issues, and then if during the discussions perhaps we can expound on that. I don't want to take much of the time. I have the privilege of calling you in the order in which you are listed. If you don't mind, allow me to call Dr. Barak Oganda, who will examine the role of legal training in strengthening county government institutions in Kenya. Then after that, we will get a regional perspective. Thank you, Dr. Mr. Oganda. Karibu.
Thank you for the invitation. Good afternoon.
Good afternoon.
All protocol observed. First of all, allow me to appreciate Council of Legal Education for the invitation to present in this conference. My presentation is based on a paper that we are developing, and I just want to, because in the interest of time, I just want to be really welcomed at the end of the presentation, so that as we develop this paper, it really meets the objectives. Well, I'm presenting Department of Political Science and Public Administration. I'm presenting a paper titled Evaluating and the scope is from 2013, when the devolved structures were officially ushered in, to 2023. So we are looking at the span of 10 years. I will not go into the details of evolution of legal education in Kenya. I will go straight to the introduction of the SAWA. We're redesigning our institutions, and we have what we call participation governance, where the public is involved in the governance of our county institution, who are skilled in handling the new dynamics of these new governance structures, including navigating regulatory frameworks, intergovernmental relations, legislative drafting in county government, compliance with public finance laws, among many others. But however, if you look at the 10 years from 2013 to 2023, if you've been following up the reports from the Auditor General and the Control of Budget, if you've been following up, you will see that our county governments are really struggling. And this struggle are as a result of non-compliance with the finance management laws and public finance laws. You'll find that even we have ghost workers within our county governance. So the question that we are asking, what is the role of legal education in ensuring that we cure this disease to achieve the objectives that necessitated them being laid down. Now, despite the decade of devolution, patterns of governance failures in county governments have become almost predictable. When the Auditor General is going to give his report, you could predict what will be reported from our county government. And despite all this, we are still pointing fingers at the political figures who are heading this county government. And the paper is trying to locate the role of professionals from the legal education and how they can ensure that they help these challenges that the county government are facing. Now, the study is employing the theory called known as reports, legal reports, official reports, academic literature that are relevant to county government, and the contribution of scholarly work, because we have a very rich scholarly work that have really addressed this issue from 2013 to 2023. So initial findings from the paper is that the patterns that we witnessed, that we always witness from the reports, is that almost every county, the many failures that are being reported could be traced back to gaps in procurement laws knowledge, contract drafting, regulatory literacy, and advisory judgments. And counties also deal with human resource constraints, understaffed legal departments, high turnover, political interference, and limited training opportunities, especially for those who are in the legal professional. Well, looking at the Article 10 of the 2010 Constitution, where we look at the national values and principles of governance, where we talk about patriotism, national unity, devolution of power, rule of law, democracy, participatory governance, human dignity, equity, social justice, among many others that are listed there. And we also look at the Article 174 about objectives of devolution and 175 about principles of devolved government. Now, on paper, Kenya's devolved system is elegant, but in practice, counties operate in messy political, administrative, and resource-constrained environments. The ideals of public participation, accountability, and professionalism often collide with realities such as political interference in legal decision-making. And looking at the question that we are putting ahead is that how can legal training ensure that the legal professions can really overcome the pressure of political interference at the county level? Because political interference at the county level is one of the biggest challenges that the counties are facing to ensure that they meet the objectives. So when you are reviewing the curricula, is there anything that you can do to ensure that those who are being channeled out of legal training institutions, they have the capacity to sustain and overcome political interfering pressures? Because this is one thing that our findings indicate that is really weakening the capacity of county institutions. And the expected landscape of devolution included financial autonomy, citizen participation, and transparency and service delivery. But, thank you. Well, in the interest of time, let me just go to conclusion, and you will read our full paper once it's published. Well, we conclude that devolution is a constitutional innovation, but it will only work if legal education evolves alongside it. Good governance depends on legal officers who can serve not just as litigators, but also as policy interpreters, ethical advisors, administrative leaders, and institutional guardians. Because if you look at the social contract, the survival of the state depends so heavily on the capacity of legal professionals to ensure that it survives and it meets the objective. Thank you so much. That is the end of my presentation.
Thank you very much, Mr. Oganda. Please appreciate him better. His conclusion was really fantastic. So as you prepare for the discussion later, please, the question he's asking us is, what are the practical steps required to ensure legal education strengthens county government institutions? Think about that as you prepare your questions. I have the pleasure of welcoming my sister, Dr. J. Murungi, to tell us a little bit about teaching AML and to draw from your experience, your vast experience. Karibu sana. Please clap for her as she gets to the podium. Motivation. Please.
Yeah, I thank you very much, organizers. Thank you for giving me this opportunity. I'd like to explain my experience in the I think it started 2016, maybe 2017, to 2020 curriculum for the University of Nairobi School of Law. We taught anti-money laundering as a standalone course. So I don't know why it was dropped. Now it is within banking law. So I speak of a time when it was a standalone course. So maybe some of the questions that we're asking ourselves, whether it should be standalone at all, whether it should be, I think it should be integrated in as many courses as possible, but also just consider as I speak whether it should be standalone. So the course outline say these were the expected outcomes. I'm just going to go through what I taught. Yeah? And it said you needed to understand the concept of money laundering. Sorry, I'm not pushing it forward. Yeah, needed to explain the concept of money laundering, its processes, the adverse impacts of money laundering, international standards, and international and regional measures. I took the course not because I was trained on it specifically, but because I was interested in the course. And as has been said here, we are trained with certain skills. You don't need to have been taught specifically about something, but you take it up. And as happens, we begin, these are the textbooks that we use, reference guide, Chasing Dirty Money, Gilmore, and so on. So when I start a new course like this, what I normally do is I scour the internet. Particularly, you'll find American universities have their syllabi online, and then I begin to check how do the different professors teach this course. But what I found was more fantastic. There is an international compliance association that trains, it's a body that trains globally money laundering certifying officers and so on. And you can request a syllabus. It will not give you the details of the content, but at least it gives you the key subsections. And to appreciate this, at our level, the part that I thought we would suit for undergraduate would be the advanced certificate. And imagine if you take it and learn it for 100 hours, do you see what you're going to be charged? You see, is it there? Let me see, it's the next slide. So the next slide, it shows you're going to pay about $2,800 US to learn this course. So not just the content, but a few other practicals. So I usually give this to my students so that they can appreciate that what they're getting from class is really, really costly, much more than their school fees for one semester. So anyhow, this is the breakdown of their syllabus. They ask, what is money laundering, the international bodies, the national legal regulatory frameworks, risk-based approach, the ongoing customer due diligence, monitoring activity and transactions, recognizing and reporting suspicions, and vulnerabilities. I add on to that, and I'll explain how I add on to that. So, Okay. I don't know whether I really have time for this, but anyway, these are the details. Inside it, if you ever go into the International Compliance Association and look for the advanced certificate, it gives you the details that I'm saying that we teach. So I track, as I teach, I track all this and track it and try as much as possible, of course, to teach per Kenyan law, because what they show there is that. Then, of course, I interest the students and tell them, oh, remember this Kafura case, and then we have the NYS scandal, and we have different cases at different times. And also that it's an international issue. Here, stronger measures in Peru, for example, these President Humala and his wife, they were detained for corruption matters, and so on. So, some people here earlier asked me, what exactly is money laundering, exactly, but Laila has mentioned some three things about, there's a process on how this wash is done. I think when people say wash, they understand money laundering, but there are these three ways it is done. And then in class, I include, these are the things now I integrate. We have confessions of a former money launderer who turns out actually to have been a lawyer. He was a lawyer in the US and he was helping people launder money. And now he's written a book, he's reformed, he consults for an organization called World Check. So if you have a transaction where you have these high and mighty people, politically exposed persons, then their website, their database is able to go in and check the details of these. Those are the things that we are being asked. Yesterday, the comments were, we need to have practical skills to do this. But anyway, he set up this. So I let them go through this interview so that they see, how was this person thinking? Yeah, what time do they work? People in the bank, they work, say, 8 o'clock to maybe 6 p.m. And then the money launderers, or those helping money launderers, they are working from 2 a.m., 1 a.m., midnight, when people are asleep, and they look for all those time loopholes when things will be easier to shift money. Anyway, he explains a lot of things, and I use this to explain to my students, and just so that they can get a feel of it. And then, here we've been concentrating a lot on the financial one, the ones related to the bank. We seem to hear more about that. But there is also the other angle of money laundering is trade-based. So I give them a journal article. And please read together with me, please, even if you are asleep, please awake just to read this quote. Please. Just turn your eyes to just read this quote, please. Just awake for this one. Let's read together, please. This John Zadonowi, she quoted, let's read together. The front door, can you see it? No. The front door of money laundering is the banking system.
Can you see it?
Okay. It says the front door of money laundering is the banking system. The government has done a pretty good job of closing the front door, but the back door, international trade, is wide open. It's so. Anyway, so we learned what is this international trade, the trade base, and so on, the trade-based money laundering. Then, of course, we have issues of privacy, because honestly, these Financial Action Task Force recommendations and so on, they are really intrusive, and we have concerns about that. Then I teach them just a framework. This anti-money laundering regime, it's divided in two. You have the aspects that are preventative and those that are enforcement, and you can read them there. They're predicate crimes. Let me not go through all those, but you have the two sections. Then, so the objective is something that Dr. Laila spoke about. The objective, surprisingly, I know we're using the word money laundering a lot, but the objective, if you read from this quote here, money laundering is not the target. The target is those activities. Those activities that underlie the money laundering, the drug dealing, the terrorism, and so on, all these the illicit land thing, so drug trafficking, blue-collar crimes, white-collar crimes, bribery, corruption, terrorism. Those are what we are looking at. All these are from one of those textbooks there, and they show you how prevalent it seems to be, and so on. So now we go to the international body setters. There are very many, but the most prominent is the Financial Action Task Force. But there are others, but this is the most prominent. They're a very powerful body, but they're not parliament. If you will see in a few moments, those things they call recommendations. There are 40 recommendations for anti-money laundering, and for counter-financing terrorism, there are 9. They're not recommendations. Say, oh, I recommend you wear blue shoes. I recommend that you wear white shoes. No, it's not like that. They're mandatory. And you can see people here from the financial institutions, DCI, they're collaborating to make sure we get out of the gray list, yeah? On the basis of something you call recommendations. So they're pretty tough, and oh my, I'm so far. Okay, so we have these bodies, and then I give them journal articles like cleaning up, and this talks about the Financial Action Task Force. Wow, I'm still on Unit 2. So we have a methodology. You need to learn the methodology, like how do you get to the gray list? That's what we go through. The students get through that. This is a very serious, and I like this topic, where we begin to look at the Financial Action Task Force, and then the students are to look for where is it in the statutes, the Pokalma statutes and other statutes. Then that way you begin to learn everything that is. It's just going through it. Here is a risk base. What does it mean? I give them the one for the legal professions, the lawyers. They have a lot of material, and they show you what does it mean to be risk-based, how to manage it, and so on. Then we've talked yesterday a lot about advocate-client privilege. There are lots of journal articles on that. And the attitude lawyers have towards being gatekeepers, many of them don't like it, and neither do Kenyans, but we have to do it through the LSK. And then we have the body that represents, let me put it that way, the Financial Action Task Force, but within the sub-Saharan region. That's the Eastern and Southern Africa Money Laundering Group. And they have reports, so we read those reports, like for example, this one on wildlife, and they show you how they do money laundering and so on. So we study this, and you can see some of those topics. I'm trying to go quickly. And the customer due diligence, we go through this, what is required. The only thing here we can't do is where they require programs. Yeah, there's a place where you're supposed to use certain programs, so we don't have those programs. We go through the politically exposed people, very important because they have a higher standard when they're doing customer due diligence. So we go through the journal articles and so on. And the monitoring here, let me just finish here. Then the vulnerabilities. Here, then I try to include some interesting things like for money laundering in football, money laundering in illegal counterfeits for East Africa, and so on. I think then we go through Kenyan case law. So you can go through, you can in your mind have a brief idea of what this anti-money laundering course is about. The students of course it's an elective, so people join as they wish. And I've had a good time learning from it and learning together with the students. And sometimes, like when Kenya was in the gray list, you begin to see students coming back and forth with answers. Or when the Central Bank of Kenya gives certain regulations concerning money, then you see the students coming back and forth saying this is the pros and the cons. So I'm happy to see, okay, they're learning, they know what the course is about. And me too, I've learned. Yeah, thank you for your kind attention. Remember, the back door is wide open for money laundering through trade. Thank you.
Please appreciate Dr. Murungi. I must apologize because this is a very rich presentation, really wonderful. Thank you very much. However, we didn't have enough time to go through it, so I'm really sorry. But I'm hoping that the CLE will actually share all these presentations, because this is at the core of good governance in any country, and integrity and democracy. So without it, I don't even know why University of Nairobi does not have it as a standalone anymore. Anyway, those are conversations. But thank you so much. Please allow me to request Professor Dr. Moni Wekesa to take the floor. Thank you. 10 minutes, Professor. That is such a difficult thing to say to a professor, but please, you will forgive me, I've said it in advance.
No, I don't need it. Yeah, thank you very much. Thank you, Chair. All protocol observed. Colleagues, I'm looking at a very challenging topic at this time and the times we are living in. And this is overcoming challenges of testing, assessing, learning at law schools in Kenya. Next slide, please. At the moment, we are faced with several challenges of assessment, and this is largely because for the longest time ever, whether in Kenya, Uganda, or Tanzania and other places, we have always assessed our students through takeaway essay assignments and essay-type questions in the final examination. But then now we are looking forward to receiving a new crop of people in 2029 who would have undergone what is called competency-based learning. And we need to be ready for them. And even before we get ready for them, colleagues, we have forms of assessments that are not very much widely used. Next slide. Or can I move it from here? Looking at that list, colleagues, we can use all of those. We can use some of them in terms of assessing learning. But then what do? We focus on the one that is marked in red only. Next slide, please. I want to take an excursion in what is called multiple choice questions. Next slide, please. Multiple choice questions enable rapid marking. We have the use of technology at the moment in which as soon as a student completes doing the questions, the test is self-executing. The student is able to see the marks immediately. As a lecturer, you can then go into the system and print out the list of students plus the marks they obtained in the card. The only challenge is setting the test. But in terms of marking, there is no problem at all. Then, of course, it has the superior advantage also of testing the entire breadth of the curriculum. One can set questions covering materials from week 1 to week 13, week 15, with relative ease. The other point about it is the objectivity of the marking, and then the challenge of large numbers. Colleagues, we are living at a time when we are confronted with very large numbers of students. I'm told of some classes where colleagues use microphones because the numbers are as large as 200, 500, 300. And now with such a number, how do you give a takeaway assignment? When will you mark it? When will you return it to the students? And then even the final exam, when do you complete marking it? These are challenges that we have at the moment, and yet we are in the business of training lawyers. So the big question, next slide please, is, are these other forms of assessment ideal for testing law skills, testing lawyers? We have focused, but on our part, some studies done elsewhere indicate that yes, multiple choice questions can be used for that. Next slide, please. The criticism against multiple choice is largely that they test memory, they are very simple, they test only memory, rote learning, they encourage people to not learn or read seriously, and that they don't test higher level learning or reasoning skills. Next slide, please. At Daystar University, we set out from 2018 to current to test whether other alternatives of testing and evaluating law skills are as good as the conventional ones. So here, the question that I want to focus on and I've focused on is whether multiple choice questions can indeed test higher level skills. Next slide, please. My time is running out. We did a quantitative study, which was retrospective in nature, in which we went in, we had administered the multiple choice questions in a number of courses, and then we did compare that with other forms of evaluation, such as oral questions, final examination, and the essay type takeaway. Next slide, please. Next slide, please. Next slide, please. Good. In our study, we looked at constitutional law, intellectual property law, administrative law, broadcast law, cyberspace law, legal research and writing. You can see the number of students involved and the number of multiple choice questions that we set for each of those courses. Next slide, please. Dr. Olo is struggling to see what I'm seeing. You can just turn your chair comfortably. Colleagues, the multiple choice questions were designed to cover all topics. They tested various aspects such as remembrance, understanding, application, analysis, and evaluation. And what we did was to avail the test from 6 a.m. to 10 p.m. But the test is timed. And the timing that we use is the number of 1 minute for each question plus 10 minutes, so that if there are 100 questions, then the test can be done in 110 minutes. In terms of the actual administration, as soon as a student logs in, starts doing the test, must complete. If he or she logs out before the test is over, the student does not have another chance at all. The test will close and give the marks. So there's no time for students to discuss. There's no time to go to ChatGPT. There's no time to even copy from a book. It's time, it's under a lot of pressure. Next slide, please. Next slide, please. Now, in terms of checking whether the multiple choice questions test higher level learning skills, we mapped our questions on what is called the Bloom's taxonomy. Next slide, please. Yeah, there is the mapping. Bloom's taxonomy talks about learning processes such as remember, understand, apply, analyze, evaluate, and create, looking at 100 questions for intellectual property law. You can see that the questions are fairly evenly spread across all forms of learning except one, create. Multiple choice questions cannot test that aspect, and that is an aspect that is better tested through the writing of dissertations. Next slide, please. An example of a very simple question requiring memory is slide, please. Distribution of multiple choice scores for legal research and writing, where we had 195 students. The marks were out of 60, not 60, out of 20. 60 is the highest number of participants that obtained a mark between 13 and 14. The results are a little skewed towards the right, but then if you remove the outliers, one sees a normal distribution curve. The test is not very easy because in this particular one out of 195, none got more than 16 marks. Next slide, please. That is the frequency distribution for intellectual property rights with 113 candidates. And here again, we see that there's some skewness towards the right, but again, none scored very highly. Next slide, please. This is the frequency distribution for final scores. That's now the individual scores again. Next slide, please. Now, Looking at 54 out of 100 MCQs for intellectual property rights, we noted that quite a number of scores tested higher level learning. We now went into intellectual property rights to look at the objective test, the oral test, the final exam. Here you can see what is called XPA plus minus sigma plus the specific figures that go to that. We did an ANOVA, and the ANOVA here was very significant, showing that the oral test was the most difficult of the three. That is the objective, oral test, and the essay type. Next slide, please. Yeah, that's the kind of the last one. Now here we see the markings across for the objective test, blue line, then oral test, final test, and then here on the horizontal we have constitutional law, intellectual up to cyberspace law. Notice that the scores are within the same range. Next slide, please. Okay, that one I'll not talk about it. Next one, please. I'm finishing. Now, here just to show us that the multiple choice questions tested higher level learnings to certain percentages across the various subjects tested. Next one, please. The conclusion, colleagues, multiple choice questions can be used comfortably to assess law courses. Other skills can be assessed through class participation, moot court presentations, and so on. Now, next one. Of these various forms of testing, we should not be suffering too much in our law schools. We have a variety of measures we can employ to evaluate our students. Let's try them out, as we have tried with the oral testing, the multiple choice. They are working. Next slide, please. So we recommend that lecturers should embrace more forms of assessing students, including the use of multiple choice questions, and that CLE should organize workshops on assessment of law courses. Thank you very much, Madam Chair. I'm done.
Thank you very much. Please clap. Appreciate Professor better. You know, this is a professor, doctor, and he has provided us a very good array of ways of assessment, which I'm sure we shall be taking in with our regulators, and with our universities to change the policies. As they say, you must have two cards, one must be this way and that way, and so on. So I have the honor now of inviting, and this organization, you should, one of the feedbacks we are giving to you and also to the hotel is we cannot be the ones blocking these beautiful presentations, surely. We should sit far away from them so people can read and benefit from them. Thank you. May I now call Dr. Lynette Osiemo to the podium. The floor is yours. 10 minutes.
Yeah. So it's not this one. This one is Dr. Olo. It's not this one. I'm waiting for my presentation. Okay. Okay, so good afternoon, everyone. Good afternoon. So I'm happy to make this presentation, and I'll try to be as fast as possible and see what I can. I'll have to jump most of it, but I hope you'll get the essence. So basically what I'm trying to do is to talk about the role of engagement, engagement of stakeholders in advancing the, legal education or dealing with the challenges of in the legal education sector and what we can do about that. And my jump-off point was the recommendations made by the Ojambo Task Force, which the report came out in 2017. Okay, so that was the fourth in my calculation, that was the fourth national report, yeah, or study of legal education. So we had the Denning Committee in 1961, the Akiwumi Task Force in 1994, the Muigai Task Force in 2005, and then the Ojambo Task Force in 2016-17. And what I think is they came up with there were serious studies which looked at many things, involved many stakeholders, and many recommendations were made, yeah? Numerous recommendations. And so what I was trying to see is, now that we were at the fourth, or we have the fourth, what have we done since the first report, or since the first study was done? The issues that were raised, the recommendations that were made, have we dealt with them? Yeah. So that was the kind of question I was trying to see. Okay, so one of the recommendations that the Ojambo Task Force came up with was recommended that the Council for Legal Education, as the regulator of legal education, should create an interface or platform for feedback on the quality of legal education and involve all necessary stakeholders, students, the public, and then regularly organize colloquiums for university lecturers, judiciaries, and so on, yeah. And I thought it was a very useful thing, necessary thing. But maybe what I was trying to see is how can we institutionalize that recommendation? Can we make it more solid, more okay, so that was the same thing. Yeah, that the idea was to create a more responsive legal education system. Okay, so what I thought is we are very much at the foundational stage of the history of our legal education. Yeah, so I don't know. Our first university was 1970, if I'm not wrong, Nairobi University Law School, which is barely half a century. But then we are in the same space, or we have places where they've had legal education for centuries, many centuries, hundreds of years, and they've been doing things. So as we set our foundations, as we set the foundation for our trajectories, could we learn something from them? Yeah. And I thought, even in this aspect of trying to navigate the studies that have been done, the reviews that have been done of the legal education sector, maybe there's something that we can learn from them. Okay, so I decided to look at the United States of America, which is over 3 centuries, 300 years. And why did I think of the USA? Because I thought they've had similar problems. When I tried to look at the history, I saw many things that we talk about, even we've talked about today, they talked about them. But then also they have a very well-documented history that you can see what they were thinking about in 1700 and what they thought about the situation then, the things they decided to do. And then also they have strong and well-established institutions dedicated to legal education. Yeah, so is there something that we can learn from them in that respect also? Okay, so I'll just quickly run through this just to show that maybe our problems are not too dissimilar. Yeah, we have very many common issues. Okay, so at one phase of their history, the problem they were dealing with was the lack of structure and professional identity. So beginning the legal education, training was mainly through apprenticeship and self-study. Law schools played a very minimal role at that stage. And there was no regulation or standardization, yeah? So at the very beginning, maybe the same challenges we were facing at the beginning of ours, yeah? That lack of structure. Okay, then in another era, in another phase, there was they recognized this need for formal education, realizing that the informal methods no longer suited the kind of economy that was developing. Yeah, so they had an agrarian economy. Now they have an industrializing society, and something about the education needed to change to adapt to that. Okay, then in the 1870s to early 1900s, we had the famous case study method of Christopher Columbus Langdell, yeah, of Harvard University. So he came up with this idea of using appellate cases to teach the students, yeah. And it was good in many respects, yeah. The idea of developing the critical thinking of students, promoted independent reasoning, and really, the goal was to teach students to think like lawyers, yeah, which is something I think we've even spoken about today. But as time went on, others criticized that method and said, there's more to being a lawyer than just thinking, yeah, that it's overemphasized on the procedure rather than the substance, and produced technicians, not socially aware professionals, yeah. So, a good method, we're coming from a stage of informality. So they try it out, and then someone says, no, yeah, we're not very happy with it, yeah, or we could do things a bit differently. So in another era, again, they realize, or they pick out the problem of a law being disconnected from society, yeah. Then they come up with other ideas. Maybe we can try a functional approach that is, more in tune with the societal needs, more focused on outcomes and not definition, that considered the context and not just precedent, not that overemphasis on what had been decided before. But then a problem was again picked with that there's no clear criteria for determining social goals, yeah? So you want us to attune to the society, but, how exactly would that look like, There was a question mark there. Then we have Roscoe Pound around the same time also proposing something else, talking about social engineering, that law must adapt to changing social conditions, and we should look at law as a tool for society. Yeah? So whatever we do should be aimed at meeting the needs of society. 1955 finds another dean of Harvard University, again complaining about the case study method, meaning it was still there. Then his idea was that he thought that lawyers were dominant in leadership, something again that we have recognized today or someone has spoken to, but the law schools were not living up to that responsibility of preparing them for those roles. Yeah. That the case method was created narrow technicians, yeah, that law schools ignored human problems and ethics, and students lacked exposure to real-world legal dilemmas. As I say this, I'm cognizant also of the fact that there are things that we speak about every day, even in our law schools, yeah? These are the same problems that we keep talking about. Then now I look to studies that were carried out to evaluate or to review the legal education sector. So one of them was in 1982 by the American Bar Foundation, and they found that there was a gap between law school and practice, and most lawyers say that they learned from experience than school. Yeah, that school was theoretic. You go there, you study to do exams, and then you go and begin learning the real thing. So they discovered a misalignment between the curriculum, professional realities, and skills. 1989, there was another report again, another study seeking to evaluate. So 1989, there was a report. Yeah. Sorry? Okay. Carnegie Foundation study again, picking up on the issues. Yeah. Then we see the problems as they came over time, or the struggles or things that we're debating. So I say that to say that we have the same issues, yeah. So what they did, we can also learn from, yeah, and not maybe repeat the mistakes that they did over the years. But the main idea I wanted to speak to was to learn from their institutions, yeah, because I think they've done a very good job at using the institutions to ensure that the things that were identified and reported over the years did not just remain in the reports. Yeah? And how do they do that? You have institutions, for example, the Association American of Law Schools, which convenes a Dean's Forum, and then under that forum, they do many things. Yeah. So if I may just, it has existed for 125 years, and in those 125 years, they have yearly meetings. Yeah. Imagine if we did that. Yeah. It would be very, very commendable. And they function as a forum for policy dialogue, academic exchange, innovation in legal education. So they have specialized capacity building events targeted at professional development. So we can do the same. We can also have a new law teachers boot camp and bring together the young lawyers, the new teachers, to discuss or to learn from the older ones. They have a dean's mentorship. And the older deans hold the hands of the younger ones as they come up. Dean Dialogues Forum, where they discuss topical issues, the things that we are raising today. What are we going to do about CBC? What are we going to do about technology and AI? Okay. Okay, I guess the rest I shall expound well in the paper. Yeah, and I hope that you will read it when it's done. Thank you.
Thank you very much. Please let's appreciate Dr. Osiemo properly. Thank you so much. It's really difficult for me, our CEO. You need to extend this to ensure that we have an annual conference. It's a challenge from Dr. Osiemo, and also of not just deans, but exactly what you have started this week, but make it 5 days so that we can have our actual experienced people to share those experiences and the lessons, because this is what enriches the work that we are doing at our schools. Thank you very much. It is now my pleasure to invite Dr. Judith Olo. Last but certainly not the least, you have the floor.
Thank you very much. Good afternoon, everyone.
Good afternoon.
As you've heard, my name is Judith Olo from Robert Gordon University in the UK. And my presentation today is on contemporary issues and challenges in legal education in Kenya, and we are borrowing lessons from the UK. So since the beginning of this conference, a lot has been said regarding challenges in the legal profession and particularly in teaching. We have talked about the student numbers, we have talked about the mushrooming of universities in counties, in the villages, and really there's nothing wrong with that. And so many conversations have been had regarding even the places where the universities or the learning institutions are located. However, very little has been said regarding the facilitators of legal education, that is, the lecturers. And so I want to turn our attention this afternoon to the lecturers who facilitate legal education and some of the challenges that they go through and how other jurisdictions have been able to manage those challenges. And so it is in this context that we look at the UK PSF, which in full is the UK Professional Standards Framework for teaching and supporting learning in higher education. So could you move the slides, please? I think I will pass this. Law remains one of the oldest professions, and it remains lucrative because it provides many employment opportunities, and this is not true only in Kenya. This is true not only in Kenya, but the world over. The number of lawyers, of course, is in the increase in Kenya, and that is the case in the UK as well, just as the number of law schools. However, there's the question of changing landscape of practice, whereby we see new matters that were not under the jurisdiction of law coming in. We see new criminal activities such as, well, cybercrime is not necessarily new, but we see terrorism as well. We see money laundering, which has been spoken about in this conference a lot. And the question is, are lecturers equipped to teach students things that they have not been taught about, things that are emerging? Is there an opportunity for teachers or lecturers to be capacity built in a way that they can deliver what they have to deliver and package it properly for the students to be able to consume it and to be able to practice it? Next slide, please. The next one. So common challenges have been identified across jurisdictions, and I have come to the conclusion that it is important also in Kenya that the UK PSF standards or an equivalent of that be adopted so that lecturers are regulated in the manner in which they do the things that they do. As advocates of the High Court of Kenya, of course, we have our regulator who looks into what we do, and we have the CPDs for continuous development. But then as lecturers, we do not have a forum whereby we are capacity built on what we do. As a matter of fact, when someone has an LLM and someone has a PhD, they plunge into the teaching practice, but they're not well equipped with pedagogy. And therefore, are we going to continue to overlook the importance of pedagogy in making a good lawyer? A PhD will not give you that. An LLM will not give you that. Experience may give you that, but it will take a really long time for that to happen. And that is why I'm advocating for law lecturers to take pedagogy training, not necessarily the like of the UK PSF, but an equivalent of that, so that they are within a certain framework of operation. They have certain controls and checks and balances within which they operate. And so the rationale for law lecturers taking pedagogy training are that legal expertise does not automatically translate into teaching expertise. I think that is now obvious, that however many books you may have read, however much knowledge you may have, you may not be in a position to translate or to relay or to deliver that message effectively if you do not know pedagogy. Pedagogy which helps you to understand student psychology, helps you to understand the environment in which you operate, and gives you an array of choices of what to do with students. We have talked about large student numbers, but student numbers is one question. How about the different needs of the students that we have? Some students have special needs. For example, I don't know, Bwana CEO, if our Council for Legal Education has catered for students who have dyslexia, for example, students who, and especially now after COVID, we have a lot of mental health issues. And the legal education in particular is a huge contributing factor to mental health challenges that students are having, considering the amount of work they have to do within a short time. A lot of people lose their minds when it comes to Kenya School of Law because it is 9 months of such rigorous work, and yet you have just 1 week to do an assessment, and that week is a do or die. And so much pressure leads to students not passing. And even the way the assessments are marked, you have either passed or failed. And so you are not told you failed. How did you fail? What do you need to do better? And so UK PSF and other relevant standards informs you on how you are supposed to carry on your duties. For example, if you're marking, what are the parameters within which you mark? How do you deliver the feedback in a way that satisfies the student? Because in one way, we operate as we offer pastoral care to our students, but at the same time, our students are our customers. They pay a lot of money to join the universities that they do join. And we are supposed to be accountable to them in terms of giving them feedback that is effective in terms of how they have performed to help them to bridge the gap, if any. Next slide, please. The long and short of it is that pedagogical training helps lecturers to design inclusive curricula, supports and equitable participation for all students, regardless of whichever background that they come from. and also enunciates your position as the person that provides pastoral care so that you know what is it that you're supposed to do. We have seen the line between lecturers and students get mad so fast that sometimes it is difficult to even try to understand how that relationship is working. Gone are the days when lecturers would when lecturers' words was like pastor's word or biblical truth. Students are now challenging what the lecturer is saying, and they're coming more to the level of having discussions as opposed to information being handed down to them, thanks to technology, because they are able to read for themselves, they're able to find out information on social media and elsewhere to challenge information that is not coming to them in a way that they trust. And therefore, that challenges your position as the lecturer. Are you comfortable with where you are at? Do you need capacity building to handle the new era of students? That is the question. And so the UK Professional Standards Framework for Teaching and Supporting Learning in Higher Education is the national framework that is used across the UK and in other international spaces, as I will show you, to recognize and enhance professional practice in university teaching. It helps us to understand what effective teaching is. With your LLM and with your PhD, you can't just walk to class and start teaching law of tort. You need to understand the psychology. You need to understand what time, are you going to put or to allocate jurisprudence for a time like this when most students are asleep? Do you understand the student psychology? That is something that counts. And so it helps us to set out, or rather it sets out the areas of activities. As a lecturer, what do you do? What is your role? And then questions around core knowledge. What is the minimum requirement in terms of qualification? What do you need to know as a lecturer? And the last are professional values. What values should you have as a person that is called a lecturer and who has pastoral care and other responsibilities towards their students? So this framework provides a shared language and benchmark for high quality academic practice. So if this is something, this is something that the CLE can consider, then I think to a large extent it would improve the quality of legal education, and it would also improve the capacity of our lecturers to be able to teach in the 21st century rather. Yesterday we were told about how difficult it is to teach, or how challenging or how different it is when you are teaching an 18-year-old and when you are teaching a 50-year-old who is taking an LLB degree as his fourth degree. Maybe he's looking to be a politician, so he just wants that degree for prestige or for whatever purpose. The way you want to treat these two groups, as Professor Kameri Mbote alluded to, is very different. At the same time, the way you teach a group of 5 students is not the same way you teach a group of 100 students. There's different techniques that you will require and to apply in such instances. At the same time, your teaching should be inclusive to take care of students who may have one disability or the other, one difficulty or the other, one challenge or the other, because as usual in such groups you will find fast learners and you will find slow learners, but all of who are your clients, how do you take care of them? UK PSF standards provide for a framework within which all students can be accommodated. And so as a scholar, I'm reminded that I need to be fast. So as someone who has taken UK PSF standards, these are the various categories that of associates or rather of fellowship that one can get. The lowest is associate fellow, which is HEA, and then there's fellow and senior fellow and principal fellow. So we also talked about employability of lecturers. If I remember what Honorable Gitobu Imanyara said, that Kenyan lawyers are being produced for the world. So if you want to produce lawyers for the world and lecturers from Kenya for the world, then you need to embrace the UK PSF standards, because this is the framework that will allow you to be employed in the UK and elsewhere. So elsewhere where these standards are practiced is Australia, New Zealand, Thailand, Canada, USA, and even Middle East. And Kenya, priding itself in being the front runner in terms of legal education in the region, this is something that is worth considering. And so as I conclude, it is important that we benchmark teaching quality in universities. We do not just take people to class who are not sure of what is required or who learn along the way, because we will not be experimenting with students. We also need to support academic professional development so that our lecturers are supported to meet international standards, and also to enhance student learning outcomes. As such, I made the recommendations that regulator should consider the adoption of the UK PSF or similar standards for teaching of law students, so that our students are getting international quality kind of teaching, and not just because we have already agreed that our students are manufactured for the global market. At the same time, the regulator to benchmark towards improvement of quality teaching and professional development of lecturers. If we embrace CPDs for lecturers, then of course we would improve standards in the profession so that we are not left to our own devices. And finally, stakeholders to think about formal recognition of teaching excellence at universities, because we pride in ourselves, or we pride ourselves in teaching excellence. We cannot call ourselves excellent if we are not marking ourselves against any framework. And so with those few remarks, I thank you.
Thank you so much, Dr. Judith Olo. There you have it, CEO. And I would actually add a fourth recommendation, that we bring her back and we organize all the schools teaching law to actually go through this. As a dean of the School of Law in Southeastern Kenya University, I have a lot of lecturers that do not know how to spell pentagogy. because it is impossible to find law advocates who are actually trained in delivery of legal teaching. And therefore, it's one of the things that CLE and our regulators should consider, because it's so critical on how we deliver, how we assess students, and even how we maintain the standards that you want us to have. I want you to all please greatly appreciate my amazing panel, and I pray that the next time they will each get 45 minutes to share what they have. Thank you very much, please. The way we were taught in the morning, please. To find so much. I don't know if we have time for discussions. It is, I'm getting your sign language. He says 1 or 2 questions or clarifications, but not another presentation, please. Oh, mwalimu yuko hapa. Mwalimu, chukua hii ufanye vile.
Merci beaucoup, Ambassade Grignon. Questions?
Thank you, Evans. My name is Ivan again. My question goes to Dr. Judy. I wanted to ask what your proposals would be with respect to practical challenges which arise from the unique situations across different countries that want to come together to standardize teaching of law, quality of lawyers, etc., etc. Thank you.
Thank you. That's the first question. We take the second one. Dr. Lowe will ask you to hold on to your question first. Do you have the second one? You can also ask the first panel. Who? We need a lady. Amma, there's a gentleman. Oh, okay. There's a lady. On the left, I'm told. Mwalimu.
Great presentations. I want to thank the panel for the insightful presentations that they've made. Speaking from where I am, I have been a teacher at the university. I have been a teacher at the Kenya School of Law, and now I'm in the regulation. Perhaps they can give us an insight on what a graduate of law, or what a lawyer hitting the market, in their opinion, should look like? Wholesomely. What is it that we want to, what are we training? What do we want to produce and release into the market? Thank you very much.
Mwalimu Director, who should answer that one?
I want to learn from them.
Anybody?
Oh, yeah, anybody, yes. Okay. My classmate and schoolmate, Dr. Lynette Osiemo, we went to Alliance together. I'm sure she has an answer.
But do we say? Hey, yeah. Anyway, so let us start with Mwalimu Konuche's question, because it will cut across. 1 minute each for the panelists. Then we will go to Dr. Olo's question, the second. Asante-san.
Yeah, I think the idea of our students, I usually tell them that, and also I tell myself, that you're competing internationally, you're not competing in your class of whatever, 280, you're competing internationally. And through my academic journey, by God's grace, I've had the privilege, you see, I studied in my master's in South Africa, PhD in Turin, been in Germany, been to Canada. I'm not doing this to boast, I'm just saying. So I've been able to watch other students and me and compare the different strengths and weaknesses. So as Kenyans, from what I see, we have, at least when I saw in South Africa, we do very well. If you work hard, you do very, very well. And then maybe in places like Germany, they have, you have to do much more discussions and critical thinking and read widely and deeply. So you have to be a person who wants to read, you have to be curious, you have to be willing to correct yourself and assess yourself. And generally, I'd say there's a lot of hope for the Kenyan graduate.
Let me just thank you very much. I'm not answering the question, but I am trying to say in a very short, brief way to just demonstrate or illustrate what the graduate that she's expecting, what you expect this graduate to look like, to be relevant to today's market.
Thank you. So yeah, I'll attempt to answer that. I think that the graduate that the world is looking for now would be one that has practical skills and competencies. In terms of reading and passing assessments, anyone can do that. But in terms of applying what you have learned, so having practical skills and competencies would be good. That would mean that you have the capacity to research. You're able to research much more than ordinary students, that is one. Number two, skills such as mooting and public speaking are also very critical, because how you explain yourself, how you put yourself out there will define you or will set you apart from your regular advocate. The last I would say is agility or flexibility. The world is changing so fast that if you are not able to adapt with the changes, how they come, then you will always stay behind. So agility or flexibility would also be something to look out for. Thank you.
Thank you very much.
Okay. So in addition to riding on what she has said about excellence in terms of the technical skills or the basics, which for me would entail a student being where they're supposed to be and doing what they're supposed to do. So in terms of being good at whatever they're learning. But then in addition to that, like our founding dean used to tell us that we want this, the business of Strathmore Law School is to produce good humans who will be good lawyers. So that emphasis on a good human, which maybe I can translate into ethical. So ethical is very important. Yeah. Then in addition to that, all the technical skills that the undergraduate should have.
Thank you.
Yeah, drawing from experiences with other schools in Rwanda and Zambia and South Africa, I would say the curriculum is okay, we are doing very well, except the challenges that have come in with us. We have two main challenges. Number one, cheating in exams at high school level to get into law schools. And then number two, the large numbers in the law schools. If we are able to take care of, especially the large numbers in the law schools, we are good to go. The curriculum is fine. So I think this is an occasion and an opportunity for CLE to sharpen its teeth and bite very hard in terms of regulating class sizes. Thank you.
In addition, from my perspective, I think the graduate of legal profession should be flexible, not only to excel in courtroom, but also to solve problems of governance that are bedeviling the country. And legal professions are very, very key in ensuring that institutions work. And because of weak institutions that we have in this country, it is very important that the legal education channels out professions who are able to turn things around and ensure that we have institutions that are working. Thank you.
Thank you very much. Dr. Law, your question?
Yes, and back to the question that was asked to me around how countries can collaborate on common challenges. I would say that if you want to collaborate to tackle challenges in legal education, you should collaborate with like-minded or countries that present the same challenges. I have given the example of the UK PSF standards, but that is just something we emulate because the situation here and the situation there are different. But clearly Kenya, Tanzania, Uganda, and Rwanda, the regions that were presented here yesterday, can collude to or can come together to fight the challenges that the legal profession faces, because we are in the same region and we more or less face the same challenges. So I would say partner with like-minded or with the countries that are in the same area or tackle the same challenges. That would remain relevant, I think. Thank you.
Partner with like-minded states. Ladies and gentlemen, that brings us to an end to today's session. Makofi ya nyayo. Moja, mbili, funga, fungua. Now, before I go to the last segment of today, allow me to recognize a very important lady in the room. Clarice Ogenga, Chairperson, Kenya National Human Rights Commission. Madam Chair, karibu sana. When I see you around the room, I'm always energized because I know you are a kindred spirit. We speak the same language, and that is human rights and commitment to the same. Welcome, Madam. Thank you very much. Now, we had two panels. The first panel is this one. No, remain first. I'll want Dr. Anne Konuche, Mwalimu, to come and present backpacks and gifts to this panel. Beginning Mwalimu Makofi, the panel are requested to come down here as Mwalimu Konuche presents the gift to you. Then we have my good friend, brother, alumni, member, Professor Wamwara. Get ready with your panel as Mwalimu Konuche finishes with this. Ataanza na mtu Alliance. It's Alliance people. Anyway, these are the good ones. Yeah, they had to tell us. Yeah, how to Alliance. And then there's the Maseno lot. Went to the school. Anyway, thank you very much. That is the good product from Alliance. Asante sana. Who next? Asante sana, madam. Thank you very much. Thank you, Doc. Asante sana. Thank you very much. And Dr. Low. Asante sana. Professor Dr. Moni Wekesa, Dean, Deister, asante sana.
So I should just take
No, you remain. We have something for you. Yes. Thank you. And the last presenter, sorry sir, thank you very much. We appreciate you coming today. Asante sana. Mwalimu, before you go, Ambassador Grignon, bienvenue. You're the last person.
I love the way you pronounce my name correctly.
Thank you. Je parle français, bien sûr. Welcome. We also start our French alliance here. Thank you, Ambassador Grignon. Thank you. Absolument. Thank you very much. Thank you. Makofi to that panel. Moja. Thank you very much. Then we have my brother, Professor Omwara, and your panel. Please welcome on stage.
Thank you.
Professor Omwara and team. No. Mwalimu asante sana. Thank you. God bless you. We welcome the CEO, Professor Jack Mwimali, to help us with this. Thank you very much. Professor Omwara's team. Dr. Laila, welcome onto the stage. We start with Professor Omwara. Thank you very much, sir. Asante sana. Thank you. Mwalimu from Uganda. Thank you very much. Ogambachi. Thank you. Thank you very much. Asante sana. Watu wa Jamhuri ya Muungano. Asante sana. Shukran. Toshukuru. Asante sana. Dr. Laila Latif, who teaches very difficult things. Thank you very much. Asante sana. Professor Omwara, everybody from your team came? Huyo tutamwekea. Thank you very much, Professor Mwimali. I think with that, we will call it an end to day 2. Tea will be served where it was served yesterday. On behalf of the leadership of the Council for Legal Education, those who have helped us make day 2 successful, thank you very much. May the good Lord bless you. I'm told to wait. Thank you very much. God bless you. And see you tomorrow. See you as we advance with the gospel of reforming legal education. Thank you.
And before we leave, we want to appreciate Mwalimu Ogada for the good work that he has done. We do not take it for granted that you have had time for us. You have spearheaded the program quite well. We really, really appreciate you. Thank you so much. And we will also receive our gift hamper. So good people, we can break for tea, and then karibu sana asubuhi, so that we can continue with the discussions. Remember that this is not the end of the conversation. For the presenters, we still expect your papers. We want to develop them, we want to document them, so that in 20 years, we will not be saying that this is an inaugural conference, rather, we'll be reflecting on what we have been able to achieve. Asanteni sana, and karibuni for the tea.